My lord, I beg to mention item number 37.
Hmm?
Item number 37, hearing item, my lord. Maybe taken up, my lord, second half. Before rising. Due to dispute up to recording up to date of birth.
May please, ma'am.
After the top of the list items, we will take it up.
Lordship,
After the top of the list items, we will take it up. Inform the,
I have informed.
after the top of the list items.
Obvious.
Item number 30, my lord, is contempt matter, and the same matter preferred appeal in division bench. It is fixed on 8, my lord, 8 of next month.
Who has filed appeal? Respondent.
Respondent, no, here they are respondent.
Respondent.
The department of
On behalf of respondent MM Kotoki.
On the prayer of your L. Deca.
LDEC.
On the prayer of Mr. L. Deca, learned counsel for the petitioner, registered to list this matter again, item number 30. After
10, my lord.
2 weeks on a date to be fixed by.
That, my lord.
It's on 9th.
8, my lord.
8, then 2 weeks it'll automatically come. How is Ms. Kotogi now?
Not much better. She was advised to take summons.
Lord, take to mention item 17, my lord. I have to file an affidavit for bringing some distinguishing factor, my lord. I have received some documents in respect of this petitioner. The finance concurrence is given to the regulation of the sports. So that aspect I want to bring some time.
Pending from 22.
My lord, but your lordship, that they said that similarly situated, but here I got by RTI some records. Some
Okay, when the matter is taken up, be here, we'll see.
my lord.
May I please, Your Lordship, with the consent of the other party, I beg to mention item number 39, Your Lordship. The learned counsel, Mr. Arbor Pujari, is indisposed today, Your Lordship.
A prayer is made on behalf of Mr. Arbor Pujari, learned Standing Counsel, Finance Department, for an adjournment in the matter on the ground that he is indisposed. Prayer is not objected to by the learned counsel for the petitioners. Petitioner. Also, accordingly, registered to list this matter again after 2 weeks on a date to be fixed. Yes.
Maybe, Your Lordship, kindly pass over the time being, my lord.
Have you given the documents?
We have given.
Get hold of Mr. Yu Sharma.
Obliged, madam.
Anything more?
Only delivery we can get.
NJ Gugui, learned counsel for the petitioner. Also heard Mr. B. Kaushik, learned Standing Counsel, Education Department. Also, the petitioner, by way of instituting the present writ petition, has prayed for a direction upon the respondent authorities for authorizing to him the authorizing to the petitioners their salaries in areas with effect from March 2012, along with their current salaries also. The petitioners in the present writ petition projects that they were appointed in pursuance to a selection process. Mr. Gugui,
What's it?
please have your seat.
That's only the petition number 3 is expired in between.
You have not substituted him.
So I informed the court there is an order, Lordship.
So there is no substitution on his behalf. Report, Nicholson. At the outset, Mr.
Mrs. Sorno
NJ Gugui has submitted that the petitioner number 3, Mrs. Swarna Buragoha Sangnai, during the pendency of the present proceedings had passed on, and accordingly, the present writ petition is not being pressed on her behalf, and the same is only pressed on behalf of the petitioners number 1 and 2. I'm sorry, in pursuance to a selection process initiated in the year 1996. Also, the petitioners were initially appointed as stipendary teachers, wide issuance of orders of appointment, wide appointment orders issued by the Deputy Inspector of Schools, Sipsagar. Also, it is further projected that the petitioners herein were also deputed to undergo the basic training course in the year 2002 and 2003 respectively. Also, on conclusion of the said basic training course, it is projected that the petitioners were authorized a scale of pay and they were so drawing their pay and allowances in the scale of pay as prescribed, as authorized to an assistant teacher in a lower primary school. Also, the petitioners also contend that IPF accounts were also opened in their respective cases, in their respective cases. As there was a irregularity in releasing to the petitioners their current salaries, and the salaries having, on account of the inaction on the part of the respondent authorities in regularly releasing the same to them, had become in arrears. However, such areas of pay were being released to the petitioners from time to time. Thereafter, it is contended that with effect from March 2012, the respondents, without assigning any reason whatsoever, proceeded to stop the payment of salaries to the petitioners. Being aggrieved, the petitioners approached this court by way of instituting a writ petition, being WPC number 114/2007. The said writ petition was disposed of by a coordinate bench of this court-wide order dated 12/4/2007, requiring the respondent authorities to place the case of the petitioners before the constituted committee, and the committee was directed to examine and consider the cases of the petitioners within the time frame so prescribed therein. Also, the state, on being agreed, state had instituted, state by way of instituting an appeal in the matter, had assailed the order dated 12/4/2007, passed in WPC number 1114/2007 before a division bench of this court. The said appeal was considered and wide order dated 18/2/2013. The same was disposed of. Noticing that the committee as constituted in the matter had already submitted its report with regard to the services of the petitioners herein, and a final decision thereon was yet to be taken. Also, accordingly, the division bench directed the Commissioner and Secretary to the Government of Assam Elementary Education Department to take a decision in the matter after affording an opportunity of hearing to the petitioners herein. Also, as the matter was not taken to its logical conclusion and the petitioners were continuing to be denied their due salaries, the petitioners have instituted the present writ petition, praying for relief as noticed herein above. You had again come to this court once more Not only that much. 2 times.
2 times.
No, this page 71 is by you.
71 is not my lordship. It is another similarly.
Similarly.
It is.
Also, Mr. N.J. Gogoi, learned counsel for the petition, at the outset has submitted that during the pendency of the present proceedings, the respondent authorities on considering the recommendations made by the constituted committee in favor of the petitioners had proceeded to issue orders all dated 30/1/2021 towards accommodating the services of the petitioners against a post of assistant teacher in a lower in a lower primary school on purely temporary basis and by authorizing to them a scale of pay. Such accommodation is projected to have been so effective with prospective effect from 1/11/2020. Mr. Gogoi submits that the petitioners now having been accommodated against a post identified for the purpose, it is found that it is to be held that the petitioners were initially recruited to their respective services by following the due procedure mandated. It is submitted by Mr. Gogoi that the petitioners herein were recruited in pursuance to a process of selection, and accordingly, any irregularity which may have existed in the selection process is always permissible to be regularized by the respondent authorities. He submits that the case of the petitioners are not one of illegal appointment. Also, accordingly, Mr. Gogoi submits that in view of the fact that the petitioners have now been authorized their respective pay and allowances with effect from 1/11/2020, this court would be pleased, in the attending facts and circumstances of the present case, to direct the respondent authorities to pay to the petitioners, to release to the petitioners their arrears of salary with effect from March 2012 till 31/10/2020. So he further submits that the period with effect from the date of initial engagement is to be reckoned, and by reckoning the same, the petitioners are to be directed to be provided pension and pensionary benefits in terms of the provisions of the Assam Services pension over rules 1969. That much only. Anything more? That's it. On a query made by this court, Mr. Gogoi has fairly submitted that the order dated 31/2021 accommodating the petitioners against various posts in lower primary schools, and as well as the stipulations made therein, have not been put to challenge by the petitioners. Also, per contra, Mr. B. Kaushik, learned standing counsel, Elementary Education Department, submits that although it is projected that the petitioners were initially recruited in pursuance to a selection process, the materials coming on record goes to reveal that the petitioners were so appointed in excess of the posts so advertised and against a non-existent post. Also, it is submitted that as there was no post available, vacant post available for vacant post available in Sibsagar district in primary schools, the pay and allowances of the petitioners were not permissible to be so authorized after March 2012. He submits that in pursuance to the directions passed by this court in various proceedings, including in the proceedings of WPC number 1048/2004, the Ihini, my dear sir, Anutaras, right? Yeah, set to soap by the for finding conclusion so vacate you. Dismissed. The order dated 31/2021 is found to have been issued during the pendency of the present petition. The said process was the said order dated 31/2021 was so issued in continuance of the on conclusion of the process of consideration of the claims of the petitioner, for which also there were directions passed by this court. The petitioners is also found to have accepted the stipulations made in the order dated 31/2021 and joined their respective services in pursuance thereof, without, however, raising any grievance objection with regard to the same. We have the above dismissed. I had passed a similar order.
Obligations.
But Miss Pidas,
Yes.
Learned Counsel, you are Pidas.
He does.
You had argued this matter. But Miss Pidas, Learned Counsel for the petitioner, also heard Mr. Miss A. Bora, Learned Standing Counsel, NHM. The petitioner in the present petition has presented, Madam, have you said, presented a challenge to an order dated 27/10/2016, issued by the Mission Director, National Health Mission, Assam, terminating the contractual engagement of the petitioner by invoking the provisions of Clause 9 of the agreement executed in this connection between the petitioner and the authorities of the National Health Mission. Also, as projected in the writ petition in pursuance to a process of selection, the petitioner herein was engaged as a assistant engineer, bracketed civil, Dibrugarh, in the civil in the National Rural Health Mission, Assam, and was posted in the Dibrugarh district. The said order was so issued by the Mission Director, National Rural Health Mission. Also, in pursuance to his such engagement, the petitioner on 21/6/2013 proceeded to execute an agreement with the District Project Manager, NRHM. Also, in terms of the said agreement, the contractual petitioner's engagement on contractual basis was for the period with effect from 21/6/2013 to 31/3/2017. Also, the petitioner, on being so engaged and after executing the agreement as noticed here in above, continue with his services at district as assistant engineer civil on contractual basis. Basing on certain irregularities, basing on the respondent number 2, basing on certain allegations of a commission of irregularities by the petitioner in discharge of his functions as an assistant manager, bracket civil, in Dibrugarh, proceeded to issue a show cause notice to the petitioner on 13/7/2016. The petitioner responded to the said show cause notice via his reply dated 28/7/2016. Also, it is in pursuance to the said process undertaken that the respondent number 2 proceeded by the order dated 27/10/2016 to terminate, to communicate to the petitioner the termination of his engagement as an assistant engineer, bracket civil, on contractual basis after 1 month from the date of issue of the said order. Also, being aggrieved, the petitioner has instituted the present writ petition. Ms. P. Das, learned counsel for the petitioner, after reiterating the facts noticed herein above, has submitted that the respondent authorities, while proceeding to issue the impugned communication dated 27/10/2016, terminating the contractual service of the petitioner, had miserably failed to take into account the reasons assigned by the petitioner in his reply dated 28/7/2016. She submits that on account of sudden medical issues faced by the petitioner, as well as family problems arising at the said point of time on account of proceedings instituted against the petitioner by his wife, the petitioner was in a disturbed state of mind and was also required to pursue the criminal proceedings so instituted against him. Accordingly, there may have occasioned a lapse on the part of the petitioner in discharge of his duties, but such lapse was not intentional, but was on account of the circumstances the petitioner had found himself to be in. Also, thus, by referring to the materials brought on record, more particularly the communications dated 22/11/2016 issued by the project engineer, bracketed civil, NHM, Assam, Zone A, Jorhat, has submitted that a perusal of the same would reveal that the said authority had brought on record the performance of the petitioner and had required the re-engagement of the petitioner as an assistant engineer, bracketed civil. Ms. Das further submits that while a communication dated 16/12/2016, the member secretary, District Health Society, Jorhat, Dibrugarh, had also required the executive engineer, National Health Mission, Assam, to re-engage the petitioner, considering the services rendered by him earlier. Also, Ms. Das submits that although they said communications dated 16/12/2016 and 18/12/2016 would bring to the forefront the fact that the services of the petitioner, although projected to have been so terminated on account of not performing his duties in the manner required, the same to be not established, inasmuch as the contentions contained in the said communications would reveal that the petitioner was promptly discharging his duties, and there was no complaint with regard to such discharge of duties by the petitioner herein. She submits that only on account of certain issues faced by the petitioner at the relevant point of time for a short period, the petitioner, in view of the attending facts and circumstances, was not in a position to discharge his duties. However, the same ought not to have been considered in isolation, and the entire service rendered by the petitioner since the date of his initial engagement as a contractual employee was required to be so reckoned by the respondent number 2 before passing the impugned, before effecting termination of his contractual engagement, void issuance of the communication dated 27/10/2016. Anything more, ma'am? Per contra, Ms. A. Bora, learned counsel for the petition, for the learned standing counsel NHM appearing for the respondents, has submitted that the very engagement of the petitioner was for a period with effect from 21/6/2013 to 31/3/2017. She submits that no stigma was attached to the petitioner while terminating his services while issuance of the communication dated 27/10/2016 issued by the Mission Director, National Health Mission, Assam, that is the respondent number 2. She submits that such termination was so effected strictly in accordance with the provisions of Clause 9 of the agreement, contractual agreement entered into by the petitioner with the NHM authorities. Also, she submits that the petition was found to have not taken requisite steps for arranging for handing over of completed sub-center buildings to the District Health Society in association with the contractors. Accordingly, it is further project submitted that such timely handing over was mandated to prevent further deterioration of the buildings while it had remained unoccupied. Also, she submits that the subsequent recommendations made in favor of the petition for his re-engagement as a assistant engineer (civil) on contractual basis made by the project engineer (C) as well as the member secretary, District Health Society, would not mandate a consideration in as much as the authorities of the NHM, after issuing due notice to the petitioner, had, upon a receipt of his reply thereto, proceeded to terminate his contractual engagement, void issuance of the order dated 27/10/2016. Ms. Bora further submits that the present petition was instituted by the petitioner on 22/5/2018. She submits that on the date when the present petition was so instituted, the contract entered into the contract, there was no extension of the contractual appointment of the petitioner, and the same in terms of the agreement executed between the petitioner and the NHM authorities had already come to an end on 31/3/2017. She submits that there being no extension of the contractual appointment of the petitioner, this court would be pleased not to further extend the services of the petitioner herein. Anything more, ma'am?
No.
I've heard the learned counsel for the parties and very well waiting you available. Govinda. Similar order, my dear. Contractual appointment. So we can keep a scoring. From idea paragraph. For example, dismissed. Ma'am, I'm only dismissing your case not for any other ground. That when you came up before this court, that contractual engagement was not there. It got terminated in 2017. Your termination order is of 2016. If you had come at that point of time, it would have been within the contract period. We could have done something for you. Yes.
Please, my lord. My lord, on the last occasion, lordship had asked some instruction from me regarding her marriage
Marriage as well as divorce.
as well as divorce. Yes. So both the things she had sent me.
You open it.
No, no, it's open. It's open already. I have kept a copy for myself. But side of. She has sent two things, lordship. One is the earlier marriage, earlier divorce, and later marriage. The paper which is larger in size, that is a part of the marriage register. That is the later marriage. And the two A4 size paper, though that is one is the earlier marriage and one is earlier divorce. And this
What is this?
this is the before divorce. Talaknama.
No, no. First one or second?
The first one is the talak.
This
The-
one. And this is the
This is the new marriage. Yes, yes.
Remarriage.
The present marriage.
Present. And where is the earlier marriage?
Worship there, actually two pages are together in the A4 size thing. So A4 size no?
This is your second marriage. This is with regard to the fresh marriage, second
The
marriage.
fresh marriage, the one which is of larger size, the copy of the register.
This is of the second marriage or the first
No,
marriage?
this is the second marriage.
Second marriage.
the current
I'm
marriage.
concerned with the second marriage. Where is the first marriage?
First marriage, those two.
This one.
Yes.
These are second marriage.
Lordship, one is the final report given by the police. That is a
Forget, I
bunch of
don't want
paper.
that.
That is bunch of paper. That is
I
one.
don't want.
Yes.
What is this first paper?
First paper.
Signed by Abdul Kalam. Abdul Kalam is your
No.
present husband.
No. The earlier husband was Hibzur Rahman. The signature will be somewhere in the up. Or Lordship, I can put through a page marker.
No.
Will be-
Zoraman, got it. So this marriage is of?
This marriage had started in 2002, ended in 2005. The present marriage,
This is the Talaknama.
Talaknama, yes. And the next page is the marriage. Earlier marriage.
From where did you get this?
That,
Where
my
did you
lord,
get this?
that, my lord, I'm not sure that the party has sent me.
Okay, this is to be registered. Was it registered before the Kaji?
Lordship, it seems that there is a signature of Kazi. There is a area, three letters.
No, where is that register? Where has it been registered in the register?
Seems that this is only available because she must have sent me everything that's available. Because in the second
And you
marriage,
got married for the second time. Registration is in 2020.
registration is done later on.
When was the marriage?
Marriage, lordship, there a date is there.
Where?
Within those columns.
Find it out for me.
I have given a small tick mark also. ইংরাজিতে
তারিখে
বিবাহ,
right.
yes, it seems that this is-
5453.
no, it is 2005.
No, there is a 3 to that side of that.
That, my lord, I don't know why that is there, but before that, it's
Why
2006.
is that in this case, in every document, there is some problem? The best way is, Mr. Counsel,
Yes,
go before the competent court, get a declaration that you are the person who is projected to be the supervisor. End of the matter.
lordship, I leave everything to your lordship. The only thing is, registry has done an inquiry. Police has
The
done an
registry
investigation.
inquiry is not final, but the inquiry which was done by the
Police.
the department, deputy commissioner, therein it is clear that there are two persons.
No, lordship, that there was no inquiry on that.
There was an inquiry conducted by the
The director, social welfare.
social welfare through the jurisdictional district commissioner. And therein he had taken statements of persons in both Katlichara first, no. The first one is Durlab Chara.
Durlab Chara and Lower
Chara,
Poa later on.
and the second one is
Lower Poa.
Lower Pora.
Yes.
And both have said that the person at Lower Para is not the person who worked in Durlab Chara.
Now, my lord, the same set of people say before the police that there's the same person.
You
Before
go
the
before the
registry.
court. We are not entertaining this.
No, I'll leave everything to your lordship. Everything is there in front of lordship.
This court cannot decide on disputed questions. And your signature varies. The signature that is there varies from time to time. And where is your identity card with regard to Durlab Chara? The identity card of the subsequent transfer post is on record, 2010 onwards. 7 also something is there. In the second case, you will find it. Or in the first case also.
Lordship, so far as whether the same person had joined who was transferred, to that effect, I suppose in the inquiry by the registry of this court, there is a specific finding that it is same person.
No, it is just it is said that it is not been able to be finally ascertained.
That also one line is there. Then there is a contradictory.
I'm sorry. We'll not go in that. Because it's a very categorical contention of the respondents that there are two persons. What is the enmity the respondents have with you?
Yes, it started from there only because categorically, because from the suspension order itself.
Okay, you come to page 46.
Yes, Lordship. This is the lower
Here
court
also,
ID card.
there is say the date of birth. No date of birth is written like this in any identity card. Equal to 1974. Now, this is a document you project to be of 2007 and again by the transferred place, not at the original
No,
place. Where
because
is the ID card of the original place?
It was transferred in 2006. And
Huh?
yes.
Till 2006, where is the ID card?
No, my lord, my humble submission is if we look into this matter as a service law matter, then, my lord, I was handed over the suspension order. That means that I'm.
No, that suspension order is on the ground. It's not a suspension order. They don't know how to project it. They say, don't allow this person to come in because she's not
Yes.
the person.
Director's order is in such way.
Such way.
But in the district, the suspension.
We are least bothered with the district.
Okay.
The action is by the director.
Now, if lordship sees on the criminal side also, then also they have taken action. And
We have criminal side, beyond reasonable doubt, there may be 101. This is a final report. It's not a case that there was a contested matter,
Okay,
then
no,
a decision.
of course.
Final order, what has happened to the police, how they have investigated, how can I go into that aspect of it? Second husband's name is?
That's it. Murtaza Uddin Chaudhary. Yes. Murtaza Uddin Chaudhary. Lordship, if first, second, third, fourth, fifth paragraph in the FR, where facts disclosed during investigation, fifth paragraph talks about this. And that, yes. And that thing has also come to light that regarding that divorce because of marriage to the petitioner's sister of Hibzur Rahman. She's also school teacher. So that has also come up in this investigation. I said on the last occasion that it was not on record. That has also come to light. May I pray, my lord, lordship may keep it for consideration and lordship may pass order accordingly.
Should we are passing it only? What is more required? You are not the person. Come to page 15.
15 of my writ petition.
Writ petition. Do you see the signature there?
Yes, lordship.
Take your that marriage register signature. This one. This one. Have you got it?
Yes, my lord.
Come to that signature. You tried very hard to copy that. But anyway, come to that signature. See how she has written D and H. D and H. Have you seen it?
Yes.
Now,
D and H of Chaudhary.
D and H. And this is maybe. Then you come to the page 45.
Yes.
All this is forceful writing. He is concentrating and writing. This is free flowing. You get my point? This is looking at and writing. We also do that. You will also have that same. And you come to now the other one. Same thing. And you now come to your affidavit here. The affidavit signature, you try to follow what is there in page 15. Whereas you write with the D with like this. You get my point? D and H you write like this. That is there in 45, in your ID and everywhere. Whereas the other Suyaja Chaudhary, she signs without that D. D, H connected. You see, it's not there. And you will find the same thing in the other writ petition in the documents there. But here, clear. It's a habit. But when she signed the affidavit here, she deliberately signed it as D separate, H separate. We are dismissing the writ petition. We say that this is a disputed question of fact. Whatever legal remedy is available to you, you take. We will not allow you. But we are dismissing the writ. Anything more, Miss Madam?
WPC, item number 5, Lordship.
Hmm.
There we have filed one affidavit,
Yes.
Lordship.
And every
And
categorical effect.
A categorical admission, and there are documents to show on record, Lordship.
Hmm.
Lordship may peruse item, page number 43, Lordship.
Hmm.
Here the preliminary inquiry, this has been there. So there is a
Do you
statement.
want further proof? Come to page 27 of the second case, that item number 5.
Of item 5, yes,
Get it? Page 27.
27, yes.
See the signatures.
Lordship is talking about the joining report.
No. WPC 7949.
No, this one.
Uh-huh.
Second affidavit.
Oh, affidavit.
Affidavit in opposition.
Affidavit, page 53, sorry. Affidavit 27. The running page 53.
Yes. Lordship is talking about the bank form.
Bank form. Therein also, have you seen the D and H are separate?
Separate.
You get my point? Whereas in all your signature documents, D and H is the same.
I got it. As a counsel, of course, I cannot.
No, you should not. You should not. This is just, we are trying to, that joining report is at page 37. See, same affidavit 37. Get my point? Now come to page 40. Your specimen signatures taken of you. One you signed somehow, page 40. No, sorry, internal page 14. This is the one.
Oh, the
No, it will be before that bank statement.
yes.
Now you see your specimen signatures. This was taken by the inquiry officer. You signed one somehow without that D, but the other two, this is called the human trait. It remains.
No, Lordship, here it seems that both are
No.
both styles.
No. She
signs.
tried. This again, you come down. You come to your now signature in the affidavit, in the writ petition.
No,
It will not match.
That Lordship, I don't have actually in my.
No, it's okay. I have it.
Okay.
It doesn't match. This is forceful because she was training herself that I should sign like this. But see, subsequently, she lost. Anyway, madam, anything more?
No, Lordship, these things are, and the preliminary inquiry report is also, Lordship, may kindly. Deputy Commissioner, Lordship, address to Director Social Welfare.
Is delivery of order not again. Yeah, 26. But the learned counsel for the parties at some length. Hearing remains inconclusive. Registry to list this matter again on 26/8/2026 as the first item.
Much
I'll pass the order.
Yes.
Yes, what happened?
Lordship, I have received the instructions.
Hmm.
If the petitioners were considered as a daily wage laborer, your lordship, casual workers. And on the last occasion, the instructions which I have submitted, there are two categories, your lordship. Employees and seasonal employees.
So if they are casual employees,
Lodge.
seasonal employees are also temporary employees,
Temporary employees, Lordship.
right? After
Lodge.
the season, they are not engaged.
Lodge.
What is the difference with casual employees then?
Casual
They
employees
are continuously engaged.
continuously engaged, but on a daily wage basis, Your Lordship.
Okay, fine.
And in fact, Your Lordship, on the last occasion, the instructions which I have submitted,
Hmm.
Lordship, I have flag marked those pages, Your Lordship, relevant pages. The seasonal employees, they got comparatively more amount than the present petitioners, Your Lordship. Here, Your Lordship, the heading is the details of VRS of seasonal employees of the Assam Cooperative Sugar Mill Limited, Purva Bamungaon, Your Lordship. Now,
You
these
have that copy?
I have that copy, Lordship.
Just show me.
See the in the instruction page. Now, these particular seasonal employees, they have got more amount than the present petitioners, Your Lordship,
Now,
because
where is that thing you said, no? That these are the highlights of you. That day you showed me one.
that was there, Your Lordship, in that particular.
In this one only?
Yes, Your Lordship.
Just find it out. It's that I have here.
Yes, Your Lordship.
Where is that? Which page? Salient features of VRS.
Lordship,
Schedule 4.
Schedule 4, Your Lordship.
Okay, show me where is casual employees here, separately shown.
Casual employees, Your Lordship, it has not been shown
Then-
here, Your Lordship.
then-
That is true, Your Lordship.
then-
That is true.
Then
Only two categories has been made out, Your Lordship. One is
permanent and seasonal.
seasonal,
So
yes,
they'll
sir.
come within seasonal,
Lordship.
right? And if they come within seasonal, they are entitled to that benefit.
Just like the other seasonal employees, Your Lordship.
So this is your latest instruction.
Yes, Your Lordship.
Where is Mr. Monto?
He's on legs, Lordship.
Okay. So this is your final instruction.
Lordship.
Ask Mr. Monto to come. When Mr. Monto is here, just inform us. We'll pass the orders. Then we'll hear Mr. Monto.
Please, Your Lordship,
Hmm.
in this case, the petitioner, he has been denied her promotion. And after,
But she retired in 2016
yes, my lord,
and then she came up before this court in 2017.
yes, my lord.
Now, how can we direct her promotion now?
My lord, my submission is that prior to her retirement,
There has to be a process for that. She'll have to assume the charge. Nothing has happened here.
my lord, in that case, my lord, that third party's case is not applicable in this case, my humble.
How?
And because that case was decided on the basis of the service rule of the West Bengal.
Forget it. Therein that it was that Satpati was given a promotion. But before he could take it up,
Yes, my lord.
he had retired.
So, my lord, there is a specific provision under the West Bengal rule that says to be assumed charge. But in our case,
Mr. Goswami, promotion, if you don't join the post, if you don't join that post, whether your pay can be fixed.
my lord, there is a decision of our High Court.
Please show me. The one which you have annexed in the writ petition.
I have not annexed that one.
Okay.
Is it exactly similar case, my lord?
There is a latest decision of the Supreme Division Bench of our court following Satpati.
I am sorry, my lord. I could not go through it.
Okay, from when, which date should we promote you if we promote you?
From the date of her application, my lord.
How can that be? There is a rule that there has to be a consideration.
Because my,
You did not come up within that period before you retired. You had come up before that. And there were some directions from this court also.
yes, my lord.
That was in 2016,
Yes, my lord.
18/11/2016. You retired on.
My lord.
31/12. Now, Mr. Goswami, let us look at another angle. You approach this court, page 42. I can't go beyond 42 now.
Yes, my lord.
So this is the direction which has to be complied with.
Yes, my lord.
Now you come to the direction at page 44. The above facts having been noticed, the counsel representing so-and-so, Rule 9 of the so-and-so contemplates promotion.
On the basis of seniority come merit.
From among
the
so-and-so,
loyalty
so-and-so,
witnesses.
so-and-so, so-and-so, not in dispute is that so-and-so at least from 1/7/20 having begun to the so-and-so subject to the entitled to a consideration for promotion. Let the required exercise undertaking for considering by provisions of so-and-so along with other eligible candidates. The direction for undertaking the exercise shall however be subject to any vacancy available in the post of so and so. Alternatively, may also consider giving financial upgradation so and so, so and so, so and so. So this exercise was to be carried out
Yes.
during your service period. Because you had not much service. You retired the next month.
Yes, ma'am.
Now that exercise has not been taken for. Maybe a violation of your fundamental rights for consideration for promotion. But where is the right to be promoted? Consideration, yes. To be promoted, not there. It is in that analogy that Amal Satpathy was decided.
Well, my submission is that Amal Sapati is not applicable.
We'll
because there is no
consider.
such
We'll
provision in
consider.
our-
We'll consider that. But going from page 42, your promotion can happen only within that time, not prior to that. It can be only after the order of this court, this one.
Yes, ma'am.
So there was no selection, and their case is that there was no.
My lord, my other point is also there because some of the juniors, they were promoted much prior to the petitioner.
But you did not make a challenge to that. Because everything was in a flux because you were brought here on attachment, then it went on like that. So you were not considered an employee of the
Directorate.
directorate. Subsequently, by orders of the government, everything, you were given a status there. They say it is from 2013. You say from 2010. This court took it as 2010. Now, whether those juniors are there from 2010 or prior to that. And you have been given your first financial upgradation.
Yes.
Nothing, but still 100 rupees change.
And there is no bar. Okay.
No bar. Absolutely no bar.
My grievance is that because some juniors were promoted.
And what
But I-
about this prescription at page 48? Second paragraph from bottom.
As per the provision of under Rule 9 of the Director Establishment Rule, her prayer could not be considered as because though she has necessary qualification for the promotion and she has rendered service more than 4 years, but her name is found in the regular gradation list of LDA at serial number 45. But at present, there is no available vacant post. That is my challenge, my lord. It was wrongly placed at 45.
Okay, let us see that gradation list.
Gradation
It is on record somewhere.
Page 39, your lordship, annexure 11.
35.
39, 39, your lordship.
Wait.
Annexure 11.
Okay. Mr. Goswami,
my lord.
this is of the directorate.
Yes.
This court held that you should be there from 2010. The exact date this court had held is
1/7/2010.
1/7/2010.
Yes.
Now you see the placement of the persons. Above you all have joined prior to 1/7/2010.
Other, sir, my lord.
Hmm?
Other, sir.
Because you were initially in a district cadre. Then you came to a state cadre. You can't carry that seniority. Now we got to undo this. But this is the position that was obtaining, and this court had accepted that. We can't go beyond that.
But prior to that page, my lord, page.
No, we can't. I
30.
can't go because Mr. Goswami, the last round of litigation, that was the date this court held to be correct. You have not disputed that.
In page 38, my lord. They have admitted that I was an employee of the director.
Okay, but what about this? On and from 1/7/2010. That is the finding of this court in page 44.
Yes. Another petitioner being a layman, they could not come at appropriate time. Nothing our fault.
But for
But
me,
they
the
were-
problem is some finding recorded by a coordinate bench is binding on me.
But she has been systematically deprived from the initial.
Understand, but can't help it. Even if property is not followed also, the facts of your case itself demolishes the whole.
That is up to your lordship, my lord.
Can't help it. We tried. But everywhere we found a blockade. Yes, who is appearing?
Your
You are
Lordship,
appearing for?
I'm appearing for lordship, respondent number 10, 11, 12, 14, 16, 17, 18, 19,
What
20.
is the name of 10?
And your lordship,
Where do I find 10 in the page 39?
page 39, your lordship,
Mr. Goswami, please have a seat. Let's just see.
Srimati Minu Devi, then your lordship, serial number 11,
Meenu Devi, 10. She is our
lordship,
you are appearing for Madam 10,
10, your lordship.
M. Dev. You are all placed above her. Okay, fine. What is your case? What is your stand?
Lordship, we have already, we are placed before her, your lordship.
Hmm.
So, and they have not challenged your lordship, the graduation list.
She says she has been wrongly placed there. She was brought there by way of a government order. So her initial when were you recruited initially, first appointment? On compassionate grounds?
24/10/1997.
Oh. So if we consider her that appointment date, she is senior to all of them.
Lordship, I need some time, your
No? Think over it. We'll have Miss Madam. Yes, what do you say?
Your lordship, we have filed our affidavit, lordship. Para 13, lordship. Petitioner's seniority in the service was counted from the date of joining in this directorate on transfer and not on the basis of joining first on appointment in office of the Joint Director of Health Services, Golaghat.
Why was that considered like that?
Lordship,
Why was that considered in that manner?
because she has joined in the Directorate of Health Services, lordship, in the year 2010, lordship.
Where do I get that?
1/7/2010. In the gradation list, lordship.
The gradation list is different from your affidavit. You were reading para 13.
13, Lordship.
So when is the
But,
date of joining in the?
In para
directorate?
11 also, Lordship, petitioner's seniority counted from the date of joining in this directorate as per Directors of Health Services, the 9/6/2010, and on the seniority basis, her promotion was subjected to be
Where is this
considered.
order dated 9/6? Is it on record, Mr. Goswami, 9/6? Annexure? Page?
Page 30.
Mr. Goswami, why was this order not projected in the manner required in the last case? Because here there is nothing here to show that your seniority will be depressed. It's a transfer in literally in public interest.
Yes.
ma'am. Moreover, my lord,
Okay.
Annexure 7,
FRS are concerned.
Petitioner's seniority was placed on the basis of date of joining in the directorate, Lordship.
Where, how? What is the basis for that fixation? Okay. Anything more? Hmm. Hmm. No, well, my question is if she was transferred there and there is in the order nothing mentioned with regard that she will not be entitled to count her past services, why her seniority will not be from the date of her initial appointment? No, I got it,
It is
different. But when you transfer it, what is the difference comes? Why?
He was transferred on attachment.
Attachment is gone. Now she is regularly transferred.
She joined
Fine, that is in pursuance to an order of transfer. The order of transfer does not say that she will be given her benefit only with effect from the date of joining. It's an order from an equivalent post to another. That is how the order is being projected. What do you have to say on that?
the coordinate bench. So it's important that he had joined the direct.
Oh, we ignored that. We ignored that. Now tell me why his seniority should not be from the date of his initial appointment, 97. Any answer, Miss Madam? Any answer to that?
That is, Lordship, if we come to page 75,
Hmm.
para 21,
Hmm.
here, Lordship, we have stated that total 34 numbers of candidates were appointed as lower division assistant in the year 2010 by this directorate, and all of them had joined in the month of May, June 2010. And accordingly, a fresh gradation list was prepared in the year
That is with regard
2020.
to the delay in preparing the gradation list. Got it.
Yes.
No, what about the service?
Petitioner has joined in the directorate on 1/7/10, and according
On
to
a
the
order of
petitioner's
transfer,
position,
madam?
the seniority list was placed
No,
on,
on a order of transfer.
yes,
Transfer is normally against equivalent posts.
equivalent post.
So why her service, earlier service will not be counted?
Because her initial joining in the district, Lordship.
Fine, you
Yes.
transferred her. We did not transfer. You transferred her. From a equivalent, that is not, those posts are not equivalent. District post and it, but you made it equivalent. Delivery of a- खूप जमीन आहे. तो खाली नाही खाली कुठं सांगणार.
As per the service rules, Lordship, petitioner's promotion is not considered as the petitioner is too junior.
Anything more?
No, Lordship. As per,
Mr. Goswami, you were in the district service
yes,
and thereafter you were brought to the
Directorate.
directorate service. You see the last line in that order, because now that you have your service has changed, you have come to a fresh service, although under the director of it, that's why they had to pass that order with regard to pay fixation. So your entry in the directorate service, it's a new service. It will be from 10/7/2010, not before that.
Lord, in that respect, one point is there, my lord. Annexure 7 may kindly be seen.
Yes.
Page 34. It was transferred to the office of the additional director.
No, it is on attachment basis.
attachment basis.
Yes, ma'am. Against a vacant post.
No, this is on attachment basis, mister. Your salaries were still coming from that, your district office.
Original.
Okay, heard Dr. P.K. Goswami, Learned Counsel for the petition. Also heard. Madam, you are appearing for response, standing counsel?
Health Department?
Health and Family Welfare
Yes.
Department, appearing for the respondents number 1, 2, 1 and 2. Madam, you are appearing for Mr. Doctor? Mr. S. Doctor, Namgita, for respond number 329. And Madam, your name? E.L. Deca. E.L. Deca, appearing for respond number? 10, 11? 10 and 11. Okay, you write it down and give. Hearing concluded, registered to list this matter again on 26/5/2026 for delivery of orders. I'll think over it, don't worry. But next day you will have to inform why her seniority she will not get. Both of you. Not madam, you both.
Have
Have you gone through?
Yes, sir.
Anything left?
No. There are a lot of things have to be addressed.
Huh?
Lord, your lordship, so far my case is concerned, I have checked it. This is a statutory post and is governed by section 11 of the Regional Rural Banks Act 1976.
Hmm.
Uh,
Hmm.
Now, if your lordship goes through that section,
Hmm.
so my limited knowledge is concerned, I don't think this
So
post
if
should be
your
crossed.
knowledge is limited, then what would be my position in this matter?
No. I don't think that this post cannot be considered as a deputy chief post. Because you should show chairman, section 11. Chairman, the sponsor bank shall appoint an individual to be a chairman of a regional rural bank. Specify the period not exceeding 5 years, for which such individual shall, subject to the provisions of subsection 4, hold office as chairman. So here the principal bank is United Bank of India, and they have appointed him to this rural bank below. So now how they can say that your service in this rural bank should be considered as a deputation service?
Otherwise, it's a service outside the parent service.
Oh,
How
yes,
will it
but
be?
I am appointing him.
You can appoint because of the provision.
Yes.
You are not, that is not a cadre post of United Bank of India.
But this has not been made clear by this section below.
Oh,
that this
then
post
you will
should
challenge that section.
be-
Then you will have to challenge that section, Mr.
No, this section, nothing has been stated in this section.
No, because see,
Let me read it out.
uh,
Provided that no appointment of such individual shall be made. If such an individual is an officer of the sponsored bank, except after consultation with the national bank, in any other case, except with the prior approval of the central government. Then, notwithstanding anything contained in subsection 1, the sponsored bank shall have the right to terminate the term of office. The sponsored bank shall have the right to terminate the term of office of the chairman at any time before the expiry of the period specified in subsection 1, provided that no such termination shall be made if the chairman is an officer of the sponsor bank, except after consultation with the national bank. In any other case, except with the prior approval of the central government. Provided further that where the chairman is not an officer of the central government, state government, reserve bank, national bank, sponsored bank, or other bank, he shall be given a notice of not less than 3 months in writing or 3 months' salary in any and allowance in lieu of such a notice. B. Chairman shall have the right to resign his office at any time before the expiry of the period specified in subsection 1 by giving such sponsored bank notice of not less than 3 months in writing. The individual appointed as chairman under subsection 1 shall be on the expiry of the period specified under that subsection be eligible for reappointment. The chairman shall devote his whole, that is not very important. Now, this is one provision.
You can have clause subrule 5 also, subsection 5 also.
Subsection 5. The chairman shall receive such salary and allowance and be governed by such terms and condition of service as may be determined by the sponsored bank in consultation with the national bank. If the chairman is by infirmity or otherwise rendered capable of carrying out his duties or is absent on leave or otherwise in circumstances not involving the vacation of the office, the central government may appoint another individual to act as a chairman during the absence of the first mentioned chairman. Okay.
Mr. Dotto, on the last occasion, you had said that his pension benefits, that pension deduction,
Yes.
normally which a pension deep salary deduction, that was being made at the scale of chairman.
Chair, yes.
So excess was deducted from him.
Yes, yes.
My lord, my lord, I'll clarify that.
No,
If I
that is their,
take
they have
the
admitted in the affidavit also.
pension regulation
In
1995,
the affidavit also, they have.
regulation 25, then 56.
Hmm.
This will cover the entire thing. My lord, I'll read the letter of the Punjab National Bank, possibly it's with your lordships.
Huh, huh.
It's
It's a
dated 6/3/2026.
Yes.
Your lordship kindly turn to clause regulation 25. Next page, my lord.
Regulation, I can give you one copy.
Yeah, regulation.
Yes.
25, huh?
Regulation 25, there's a period of deputation to an organization in India. Period of deputation of an employee to another organization in India will count as qualifying service, provided the organization to which he is deputed or the employee pays the pensionary contribution at the rate specified in sub-regulation A of regulation 7 of these regulations, or at the rate specified in the bank at the time of deputation, whichever is higher to the bank. Now, the employee pays means, my lord, as your lordship knows, there's a basic pay. Now, your lordship may turn to regulation 56, which is very important. Residuary provisions. In case of doubt in the matter of these regulations, regard may be had to the corresponding provisions of Central Civil Services Rules 1972 or Central Civil Services Commutation of Pension Rules 1981. Then your lordship may skip the other lines. Then additionally from there. Additionally, in response to IBA letter number so-and-so dated 4 July 1998 on the subject Bank Employees Pension Regulation 1995, emoluments to be reckoned for the purpose of, yes? You said it.
Already.
Emoluments.
I'm not getting all these things in the pension regulations.
No, he's not reading the pension regulations,
Oh.
Mr. Gupta.
Oh,
He's reading that
The last time I have given,
that-
no, yeah, you gave this page. I have taken it.
It is there. I'm showing. Give it.
No, you bring it from this.
Give it. No.
No,
From my reading, my lord, I want to show him. He's reluctant to take it. Anyway, you go on your own way. My lord, the emoluments to be reckoned for the purpose of pensionary benefits in the case of an employee is on deputation. Department of Economic Affairs, Banking Division, Minister of Finance, Government of India has issued notification number so-and-so dated so-and-so, wherein IBA has directed to refer Rule 33, Note 7 of CCS Pension Rules 1972, which is quoted under. It has been decided, this is important one. It has been decided that substantive pay that an officer would have drawn in the parent bank, but for the deputation, be taken as the pay for calculating average emoluments to the purpose of pensionary benefits and not the pay actually drawn by the officer in the higher scale from the loanee organization. So in this case, what happened, my lord? He was in United Bank of India. He was sent on deputation
to the loanee organization, that is the borrower organization, the Manipur Rural Bank. Now, in course of emoluments, what basic pay will have to be taken into
You read
consideration?
that that Punjab National Bank Employee Pension Regulation.
Yes, yes.
Can I just have a copy?
Give me the extra copy.
I have the copy.
25, 26.
25, 56, those will be the very relevant part, my lord. 25 and 56. I don't know. Give that to- No, no, this
Yes,
regulation.
this will be United Bank.
Same thing, the regulation is same. my lord. Lordship may come to 25 first. Before 25, your lordship may see the 7 also. Composition of the fund. 7A, the contribution by the bank at the rate of 10% per month for the pay of the employee. ওটা মুখস্থ আছে না? Extra copy আছে?
Extra copy.
7 is not here. That 7 here is something different. He'll be covered by Punjab National Bank or United Bank regulation?
Now it's earlier it was United, now it is Punjab.
When he was.
But the regulation is in parametry.
When you retired, it was Punjab or
Punjab,
United?
regular, United Bank.
When you retired?
But it is in parametry, my lord, there is
That is
no
different.
difference.
No, 7 is not here.
7, this is a composition of fund possibly that maybe in some other regulation, my lord.
Let us see what is 25.
Then let us come to 25, my lord. Period of deputation to an organization in India. So copy is there?
Yeah.
एक ही लेके आता है क्या? Is it the same, my lord? No, no. 25 is 25. That can be any other thing.
Twenty-five is different, something different here.
My lord, your lordship may see the IBA guidelines, that is the letter which I have given other day. Your lordship will find the same thing quoted here also. Some of the letters from Ministry of Finance, then IBA. Lordship may kindly see the IBA letter, my lord. This is dated 27 January 1949, 1948 shell. What is this? What is the date?
Where do I get it?
January 11, that the compilation I gave the last time.
It's an annexure to that.
Yes,
Appendix
connected to that.
IBI letter, okay.
IBA letter, my lord, dated January 11, 1999. It's to the bank employees pension regulation 1995. In terms of regulation 25 of the bank employees pension regulation 1995, the period of deputation of an employee to another organization in India will count as qualifying service provided the borrower organization pays to the bank the pensionary contribution at the rate of the 10% per month of the pay of the employee or at the rate specified with the bank at the time of deputation, whichever is higher. Basic pension is calculated as percentage of average emoluments, which is determined with preference to the emoluments drawn by the employee during the preceding 10 months from the date of retirement. One of the public sector bank had inquired about computation basic pension in respect of an officer employee who was deputed to another bank on a higher scale.
Got it.
And then, my lord, the next letter also, your lordship can see, is from the Ministry of Finance,
Hmm.
Department Finance Services,
Dated 23-1.
23-1. Appointment of chairman of RRBs. We have received requests from various sponsor bank regarding relaxation of age. We are not in regard to the age. Your lordship may see Roman 2. While fixing the pay and allowances of chairman of RRBs on their appointment, the IBA fitment pattern may be followed. In case any of the chairman of RRB is promoted to scale 6 during the tenure as chairman of RRB, his pay shall be fixed in the scale 6 and deputation allowance as applicable will be paid to him in lieu of the higher scale. Now here your lordship will find the term, the deputation allowance, because the scale 6 was the last scale. Beyond that, there at that relevant time, scale 6 was the last. So therefore, he cannot get the higher scale 7. It was the higher scale 7
You
came.
got it, Mr. What you are trying to project is that
Well,
the pension contribution, etc., everything would be for treating that period also as qualifying service for pension.
exactly.
But where the actual commutation of pension comes into question, it will be 10 months that he will otherwise draw but if he had continued in the
Parent
organization.
Parent organization.
Yes,
That's
Mr.
the-
Adasupta.
Yeah, no, well, I have concluded that.
But Mr. Gupta, Learned Counsel for the petition, also heard Learned Senior Counsel assisted by Ms. B. Das. Also heard Mr. S. Dutta, Learned Senior Counsel assisted by Mr. S. Dutta, Learned Counsel appearing for the respondent number 2, respondents number
Respondent 2 to 4.
2 to 4. And 5 also, Manipur Rural Bank.
No, Manipur where?
4. None has appeared for the respondent number 5. The petitioner in the present petition has assailed a communication dated 20/2016 issued by the chief manager bracketed staff pension towards revising the pension and pensionary benefits authorized to the petitioner pursuant to his superannuation from service. Also, the facts in brief requisite for adjudication of the issue arising in the present writ petition is noticed as under. The petitioner had joined the services of United Bank of India as a clerk on 22/12/1977. The petitioner, by riding the ladder of promotion, was promoted as a scale 4 Roman 4 officer in the month of June 2010, and on his such promotion, he was posted as Chief Manager, Silchar branch. While the petitioner was so posted as the Chief Manager, Silchar branch, he came to be appointed as Chairman, Manipur Rural Bank, wide an order dated 13/7/2011. Also, the petitioner accordingly proceeded to join as the chairman of Manipur Rural Bank. It is to be noted that United Bank of India at the relevant point of time was the sponsor bank of Manipur Rural Bank. Also, the initial appointment of the petitioner as the chairman of Manipur Rural Bank was for a period of 3 years. However, the same was further extended by a notification dated 31/12/2014 with effect from 1/1/2015 to till the date of his retirement, which was to occasion on 30/4/2015. Also, it is projected in the petition that the petitioner, on attaining the age of superannuation, proceeded on retirement with effect from 30/4/2015. On his such retirement, the petitioner, the pension and pensionary benefits of the petitioner was finalized by reckoning the pay and allowances drawn by the petitioner as the chairman, Manipur Rural Bank. Accordingly, the said computation being made, the pension of the basic pension of the petitioner after reckoning the revision coming into being was fixed at 38,105, and accordingly the other pension and pensionary benefits of the petitioner was so calculated. However, while a communication dated 20/2/2016, the petitioner was intimated that his pension and pensionary benefits would now mandate to be revised and refixed inasmuch as an error had occasion in fixation of his pension and pensionary benefits, as the same was so computed by reckoning the pay drawn by the petitioner as chairman, Manipur Rural Bank. Also, accordingly, while they said communication dated 20/2/2016, the basic pension of the petitioner was reduced and fixed at rupees 34,775. It was further stipulated therein that an amount of rupees 1,61,248 would mandate to be recovered as excess pension already paid to the petitioner. Also, being aggrieved, the petitioner has instituted the present writ petition. Mr. D. A. Dasgupta, learned senior counsel, by reiterating the facts noticed herein above, has submitted that the petitioner, while being appointed as the chairman, while being transferred and posted as the chairman, Manipur Rural Bank, was, in terms of the procedure, in terms of the provisions so made, authorized the pay of a senior management grade scale 5 officer. He submits that the petitioner, as the chief manager, Silchar branch of the bank, was drawing his pay and allowances in senior management grade scale 4. Also, thereafter, on the promotion of the petitioner in his parent bank to that of scale 5, the petitioner was authorized his pay and allowances as the chairman, Manipur Rural Bank, with effect from 13/6/2013 in scale 6. Also, Mr. Dasgupta submits that the petitioner, while being so authorized his pay and allowances in scale 6, proceeded to superannuate from his services with effect from 30/4/2015. Mr. Dasgupta further submits that the pension contribution was being made by the petitioner during the period he had continued as the chairman, Manipur Rural Bank, at the rates at which he was being authorized by making deductions, reckoning the scale of pay authorized to him during his such postings. Mr. Dasgupta submits that that the deductions as made towards pension contribution was admittedly being made at a higher stage than that the petitioner would have been required to make as if he had continued in the parent bank. Also, Mr. Dasgupta accordingly submits that by taking into account that the pension being determined by taking into account by reckoning the emoluments payable to an employee for the past 10 months prior to the date of superannuation of such employee, such calculation being required to be so made by reckoning the pay of the petitioner to be so authorized to him in scale 6 as the chairman, Manipur Rural Bank, the computation as made with regard to the pension and pensionary benefits in respect of the petitioner was correctly made, and the same had not mandated any revision. Subpara. In the above premises, Mr. Dasgupta submits that the communication dated 22/2016 issued towards revising the pay and allowances of the petitioner only on the count that the petitioner, although had continued as chairman Manipur Rural Bank, with a higher scale of pay, would not be entitled to reckon the pay and allowances drawn by him in the said bank, and his emoluments for pension would have to be reckoned by treating the pay the petitioner otherwise would have drawn if he had continued in his parent bank to be clearly unsustainable, and prays that the order and submits that the order and the communication dated 22/2016 would mandate an interference from this court. Anything more?
I have also referred to section 11.
report Mr. Dasgupta, in support of his submissions, has referred to the provisions of section 11 of the Regional Rural Banks Act 1956. 76 to highlight that, and Mr. Dasgupta has further referred to the provisions of section 11 of the Regional Rural Banks Act 1976 to highlight that the contention of the respondent bank that the petitioner had proceeded on deputation to be erroneous, inasmuch as subsection 1 of section 11 mandates that the sponsor bank shall appoint an individual, including an officer of the bank, to be the chairman of a regional rural bank. He submits that there is no element of deputation involved in the matter, and the petitioner was also not authorized any deputation allowance while he was so posted as the chairperson, regional rural bank. Per contra, Mr. S. Datta, learned senior counsel, appearing for the respondents number 224, has submitted that the petitioner's appointment as chairman, Manipur Rural Bank, being an appointment beyond his parent service, the same can only be construed to be one so affected on deputation. He submits that the deputation allowance not being released to the petitioner would not change the character of the appointment effected in respect of the petitioner, inasmuch as in lieu of a deputation allowance, the officer so posted to a rural bank was authorized a scale of pay at the next higher stage than that what was being drawn by him in the parent bank. He submits that the petitioner at the time when he was selected for appointment as selected for posting as the chairman, Manipur Rural Bank, the petitioner was a scale 4 officer. However, on his such appointment in the rural bank in question, he was authorized initially scale 5 and thereafter scale 6 on his promotion to scale 5 in the parent bank. Mr. has further submitted that in terms of the provisions holding the field for the purpose of fixation of pension and other pensionary benefits, the emoluments drawn by an officer of the bank during a period of 10 months prior to the date of superannuation of such officer is reckoned. So, an officer on deputation being so appointed in a service foreign to that of his parent, foreign to that in a different service other than the parent service in the bank, for treating such period of foreign service to be a service rendered in the bank, and also to treat the said period, such service as qualifying service for pension and pensionary benefits, the officer concerned and the organization to which such officer is deputed is required to make monthly payments towards pension contribution of the officer concerned at the rates specified in the regulation and or at the rate that may be so specified by the bank concerned. Mr. Dutta submits that the petitioner was remitting his pension contribution by making deductions at the rate of 10% per month in the scale of pay authorized to him. In the basic pay at the higher scale authorized to him. Accordingly, he submits that the period of service rendered by the petitioner as chairman, Manipur Rural Service, would be deemed to be qualifying service for the purpose of computation of his pension and pensionary benefits in the respondent bank. Having made the said submissions, Mr. Dr. Learned Senior Counsel has further submitted that reckoning the said period as qualifying service would not have the automatic effect of also requiring the respondent bank to compute the pension and pensionary benefits of the petitioner by also reckoning the scale of pay, the emoluments drawn by the petitioner at a higher stage as chairman Manipur Rural Bank for the purpose of fixation of his pension and pensionary benefits. It is submitted that the pension and pensionary benefits for the period the petitioner had continued as the chairperson of Manipur Rural Bank would be so computed by reckoning the pay that would have been authorized to the petitioner had he continued during the said period as an officer in the bank. Mr. Dotto has further placed reliance upon a communication dated 27/1/1999 issued by the Indian Banks Association to highlight that the matter on being taken up, the issue on being taken up with the Government of India in the Ministry of Finance bracket banking division bracket over, it was advised that pay that an officer would have otherwise drawn in the parent bank, but for his deputation, was to be taken as the pay for calculation of average emoluments for the purpose of pensionary benefits and not the actual pay drawn by the officer in a higher scale in the LEASE, L-E-A-S-E-E organization.
It's a loaning.
Loni. Loni. Oh. EA all have got mixed up bits because there is a green mark there.
Yes, I could understand. That's why I just.
Loni organization. Also. In the above premises, Mr. Dotto submits that on a error committed by the bank, the pension and pensionary benefits of the petitioner came to be so calculated after his superannuation from services by reckoning the pay drawn by the petitioner as chairman, Manipur Rural Bank, and the same on being finalized, the benefits thereunder was released to the petitioner. However, the said matter coming to the notice of the authorities, a revision was carried out in the matter and a recalculation of the pension and pensionary benefits receivable by the petitioner by applying the permissible parameters was carried out, and wide notification dated 20/2/2016, the same was intimated to the petitioner. He submits that on account of the revision of the pension and pensionary benefits, requisite only on the ground, requisite because of an erroneous calculation carried out earlier, an amount of rupees 1,61,248 was recovered from the petitioner for the pension as released to him pension and pensionary benefits released to him for the period 1/5/2015 to 31/1/2016. So in the above premises, Mr. Dr. submits that the petitioner cannot take advantage of a error committed by the bank in computing his pension and pensionary benefits and in the attending facts and circumstances of the matter. The computation of pension and pensionary benefits as made by the communication dated 20/2/2016 being in tune with the procedure mandated in this connection, the communication dated 20/2/2016 would not mandate any interference from this. Anything more? Mr. Dasgupta, sorry, dismissed. We'll pass the concluding section. Conclude query. Wait on the delay. You will have it.
No,
Not
there's
sure.
only one thing that I would like to mention. So far the IBI circular is concerned, it may have some.
Mr. Dasgupta, this was something which I had missed out. I had missed out one thing the other day, is that the pension contributions are for treating that period as qualifying service only.
I am not very much impressed on that one, Milord.
Oh.
My view is that so far the IBI circular is concerned.
Yes.
This is with regard to the deputation list. But whether my post is my post
I think-
chairman is a
I think that's why when I was recording this submission of Mr. Dotto, I had brought it on record that it's a foreign service. It's not within your. So it has to be deemed to be a deputation.
So far that is Sangha, if it is clarified that while fixing the pay and allowance of chairman of RSB on their appointment, an IBI treatment pattern may be followed. In case any of the chairman of RSB is promoted to scale 7, my scale 5, during the tenure of chairman, his pay shall be fixed at the scale of 7 and deputation allowance as applicable will be paid to him
Now-
in lieu of higher scale.
Now that is what I'm saying.
No,
You are
I
given-
think this is a circular.
No. Circular,
Whether
forget
this
it.
circular can
Circular,
override the statutory provisions or not. Am I bound by this circular when there is a specific provision under this Act of Parliament that the appointment is being made by the sponsored bank? If the appointment is made by the sponsored bank, how you can say that this is a post of deputation?
Mr. Dasgupta, what has happened here is till you reach 6 in your parent organization, that means 7 in the rural bank. Till that time, you are not entitled to a deputation.
Yes.
Moment you moment you reach 7 here, you will not get 8. Now you will get 7 plus deputation allowance.
Right.
But in bottom, you went from 4 to 5. 4 to 5.
No, I am not concerned with the deputation allowance.
That you will get it in.
No, deputation allowance is given for because the person.
Mr. Dasgupta, that clarification is available in page 24 of your writ petition.
No. So far the deputation is concerned, when a person reached in the scale of 7, then and only then he will get the deputation allowance. Otherwise not.
No.
Why is the reason? Reason is that you have attained this higher scale. Despite attaining the higher scale, you are going to serve as a chairman post. So for that part, rendering of service, you are giving some special allowances.
No.
There is deputation allowance.
Subject to correction. My understanding is 4, 5, 6, 7. 4 claims. Say a man goes from 6 to scale 6 to a rural bank.
Then
he will be placed at scale 7 there. Now that person gets promoted to scale 7 in the parent organization. So from 6 to 7, say he worked for 1 year. He was in 6, in the bank. He went to rural bank. He is placed at 7 there because one step higher. Now, moment he is placed at 7 there, he continues for 1 year.
Yes.
Now, within this 1 year, this man from 6 gets promoted to 7. Now, he cannot be given 8. Normally, it
Because-
is one stage higher.
Because of the fact there is no 8th grade post.
Okay. Now,
So,
he cannot be
you are-
given.
Despite
Now,
not
what is
having,
given is, now what is given is because you both are in the same scale of pay. In the rural bank and in the normal, in the parent bank, you are in the same scale of pay. Additional deputation allowance, 20-30%.
why,
that is given.
why? That's
No, that
Exactly
is
that.
what.
Exactly
Now,
that.
now you reverse that situation, Mr.
But-
Dasgupta, kindly reverse that situation.
Hmm.
When you're going from 4 to the rural bank, you're
5.
placed in 5.
Five.
You're placed in a higher scale.
higher scale.
So you do
Now,
calculation.
when you are in scale 7, you are going to scale 8. You should go to a scale 8.
But that
But
is
there
not
is,
there.
as there is no scale of 8,
So
8,
deputation allowance.
it is compensated.
Thank you. I got it.
There is compensated. For that reason, it was making.
We'll conclude it.
You're confused.
This is just the first order of a puny judge. There are forums ahead.
That's right. Whether I will have it or not subject to.
That's different. But interesting.
But what I feel that
Interesting.
it is a statutory post. Be governed by section 11. Whatever circular you made, you can make. This will not override the provisions.
Now, okay, tell me.
And if you go
Okay.
to this section,
Okay.
form and substance of
Okay.
this is not a post
Okay.
of deputation. That is my only condition.
Okay, got it. This rural bank is a different concept altogether. It has got nothing to do with United Bank.
Why not?
United Bank will manage that as a sponsor bank.
United
Otherwise-
Bank has a share.
Okay, fine. But otherwise, the employees in the United Bank, say in Silchar or in Manipur, United Bank are there. There is United Bank in Manipur also.
Yes.
The person cannot be transferred there. That a clerk in
No,
United
A
Bank
person can only be
Imphal-
transferred.
transferred to Manipur.
No,
it
a
cannot be.
transfer can be a bank employee of United Bank can only be transferred if he holds the post of chairman.
That's it. Others are
And
not,
that is a statutory post.
others are not allowed. So that is not a cadre post.
That is different.
No,
Whatever, that is
because
statutory
to
post,
understand the limited knowledge that I have, to understand deputation, concept of deputation, we'll have to understand the cadre, the principle of parent service and cadre. And then come to know whether this is a service beyond the cadre. If it's a service beyond the cadre, it has to be in deputation. Thank you. Got some opening here. Anna, both of you, because we were with this matter for a long time.
That's all right.
I was with you initially.
No problem.
Thank you. Mr. Dasgupta, you will not have the order before Wednesday. Because I may not be here on Monday and Tuesday. May not be, not sure. May not be.
Sorry, my lord.
Mr. Monto,
My lord.
the final conclusion of Mr. Odolo is, last time he was that seasonal worker. We are only giving 22 days. I said, why not the full thing? Now he has come up with another plea from the liquidator saying that seasonal worker is different, casual worker is different. Casual worker, there is no provision. If you are a recognized casual worker,
My lord.
whether you will be getting VRS benefit, that is his question.
No, that has benefit, yes, my lord. But how they calculation? What
They say that was the area which
My
you were to receive, that you gave it finished.
only 2200, my lord.
That is the pay you get at that point of time.
That is 1 month. But that cannot be how it is. The
So
way they
you are not they say you are not covered because we don't treat you as an employee, permanent or a seasonal employee.
no, we are casual and seasonal employee. We are casual and seaman.
So they say you are casual employees.
No, we are all casual. That's
That they have not used the term seasonal is a different context altogether.
But in para 14, we have stated the petitioner begins to state their master rule, casual and seasonal employees. The sugar mill. They have not denied it, my lord.
They say you are not there in the list of seasonal workers.
Calculation, my lord, your lordship kindly the VRS benefit as well as closure benefit. It's a closure benefit, my lord. They close.
Closure benefit, he says that there is nothing. How do you require, how this court should now approve?
My lord, if
As
they,
a senior counsel, I must say.
so I am submitting before your lordship, my lord, and we are working for the more than 14 and 15 years, about 14, 15 years. And they are getting the, what basis they have calculated? Am I entitled to get only 1 month salary, whether closure benefit or the.
That's what I'm asking you. Being
You
a
cannot-
casual employee who is having a daily wage, what more should you be getting? I want an answer to that. How do I approach this? You get the point. There is a VRS
My lord, VRS scheme, my lord. No,
you will
they-
have to bring yourself, you can't bring yourself within the permanent category.
correct, my lord.
You will have to bring yourself in the next category, seasonal. But they say we have distinguishing factors of seasonal and casual.
Casual,
Casual is daily wage,
my lord.
which I'm finding it difficult to accept. I want your input on that.
Regarding casual.
How do you come within that VRS scheme per se? Is the VRS scheme on record in the petition?
No, man. The scheme that is in their hand, my lord. We are the employee casual worker. How can I get it, my lord? That is.
My lord, the earlier order of this court, is there a distinction made between?
No, my lord, they only, my lord, that while sanctioning the amount that they have, my lord, regarding VRS who are entitled, they have given a 855 employees list, man. Our names were listed in that list, my lord.
Come to page 54, para 25.
My lord. Yes, counsel preparing respondent was shown that the claim of who serve as a seasonal worker, and a casual worker, fixed pay worker in the sugar mill have not received their dues. In fact, they have been paid VRS due only to 2200. As at this stage, Mr. Uzi and counsel petitioner submit that so far as permanent and casual worker are concerned, they were used to pay salary during the season, and during the off season, they used to be paid retainership. Retenship. The possible will be that that they have been made by the official liquidator that due to the employee of the account of income tax.
This court did not go into that aspect of the matter. Whether you are a casual or there is a difference between a casual and a seasonal.
But the list which was prepared for VRS, my lord, that in less 855 employees, my lord.
And you are there.
And our name was included in there.
Okay, let us see that list. It is on record.
My lord.
I think, you have brought on record, I think, that list. Yes, it is there.
No, 855 পিছত যাম।
The names of the petitioners are there in that list.
Lordship.
No, that I made a statement, my lord, they have not denied. In fact, my lord, in earlier round of litigation, my lord, it is very clear, man. And list we have submitted from the authority list was submitted from the authority of the sugar mill, my lord.
Okay.
That is, my lord, earlier round of litigation, there is a court order, my lord.
Now, if you are purely a casual worker, and this court, last occasion also that matter coming to the notice of the court not having passed any order thereon. How do we proceed with that? Because it is clear that there are three categories of employees: permanent, seasonal, fixed, and casual.
My lord.
Now, fixed and casual cannot be treated as employees. So they are not entitled to any leave.
My lord.
VRS benefit is also 15 days pay for every completed month or the month left, period left.
My lord.
So now how do we say that a fixed employee will continue? Because he's a daily wage worker. He comes, he goes.
That's correct, my lord. But here in all are not casual. Some of them are, my lord, they are seasonal, my lord.
Where?
My lord, that clear picture is not there, my lord.
Where?
In para 14, I have stated, my lord, your lordship kindly see, the petitioner back to state they are master rule, casual and seasonal employee of the sugar mill worker. They work in the sugar mill for last 13, 14 years, but the sugar mill was closed down by the government of para 14, page 37.
In fact, your lordship, the petitioner number 12, he seems to be a seasonal worker because his name is reflected among the seasonal workers, your lordship, in the list, your lordship. I have marked it, your lordship, serial number
Do one thing.
120. Lordship.
You give a list, that list to Mr. Borwa.
Lordship.
Huh?
Lordship.
If there are seasonal workers
Lordship.
involved in that amongst the petitioners, we'll pass a separate order for them.
My lord.
And so far as fixed and casual, I think
They will not get.
they will not get.
Lordship.
But the Learned Council for the parties at some length. Hearing remains inconclusive. Raise me to list this matter again on request for it. No, hearing. Yeah, good news. Nice. 90.
My lordship.
And if we get that details,
No.
we'll dispose of the matter,
My
saying that seasonal workers, as per Mr. Bodlo is undertaking, that they will have to be given that
My
pay
lord.
in the manner required. Casual,
My lord. I
Sorry.
understand. My lord.
and if you can find out something, tell me, Mr.
My lord.
And Mr. Borua, do that exercise.
Yes, lordship.
You give him that list,
Lordship,
that list which is.
I'll give it.
Anything left here?
On 3-4 points I want to argue.
No, you argue,
Yes, sir.
but whether it will be an academic exercise or there will be something.
Because lordship, this is a petition co-warrant of petition.
You have retired.
I don't have claim, lordship.
So now only thing we got to look into is whether the respondent who was appointed had the qualification for that appointment,
Yes, lordship.
right? Now, this matter was considered by the Commissioner and Secretary. And he has systematically dealt with the matter. I don't find anything erroneous. And with regard to that departmental proceedings to be drawn up against her because she had proceeded without permission, those things will not.
Yes, lord. That's true. I want to press 3-4 issues, lordship. I mean, come to the advertisement. That page.
Yes. Page.
Even candidate is 53. Yes, 57.
ৰাতিপুৱা আহিব বোলে গম পালে থৈ কিনে দিলো
It is page 57.
57. Okay. Yes.
Three advertisements. First, it was by filing some requisition, it was not acted upon. Then the second one is re-advertised. And then thirdly, the
57 is the final one.
no, the 59 is the final one.
59. Okay, let us go to 59.
So here,
And mind you, the lady has also retired, I suppose.
no,
She's continuing.
company. It's of the year 2017.
Okay. Yes. What do you have to say?
First of all, last point, the candidate must possess commanding personality, administrative ability, and leadership skills. Now, if I see the mark sheet, there is no leadership skill. No marks was given. And as per the advertisement, she must possess, she must have the
Was
leadership.
marks given to you?
I'm showing it. Yeah, I'm not the candidate. Also. I'm not challenging. It is a co-warrant to petition also. It's for co-warrant also.
So you are not the.
I'm not the candidate.
So you are not the candidate.
Yes, sir.
Oh. Okay. Now
Yes.
tell me, what is the violation of the rules? Forget the advertisement. You are now co-warrant. Without authority, she is holding that post. Now show me what is the violation of the rules.
Yes, no, sir. I have to show that only.
That she is not having qualification.
Yes.
She was appointed by a person not authorized to appoint her. These would be the basic things which this court in a co-warrant. Show me.
Now, first may come to page 28.
Just a moment, just a moment, just a moment. You were one of the candidates in the selection process. No. Who was the candidate other than you who had gone up on appeal?
That's, I do not have the information. They did,
Just a
they
moment,
did not
just
go
a
for appeal.
You had come up before this court earlier also.
No. If some other person come, and for that the first advertisement was,
Bipul Mek, son of British
yes,
Mek.
yes.
You also, Bipul Mek, son of British Mek.
Yes.
Huh?
Initially, he came and he has prayed before this court to take into consideration that representation which were pending before the.
No, he is the senior most teacher in BNP Higher Secondary School.
But he did not participate.
He did not.
He did not participate.
Hmm?
He did not participate. There were 7 persons who have participated.
I found somewhere. Where is that? Huh?
My lord will find at page 30 are the 7 persons who participated.
So he was not
No,
one of
no.
the candidates.
The person who secured more marks in the first position,
He went to some
he
other
went to some other school. And they
Okay.
responded.
Now,
Then, which is what do you want to show?
page 28.
28.
8.
Hmm.
Here, Lordship, first thing, the signature of the parents member is not available.
That has been dealt with.
Secondly, Lordship,
Mr.
date
That
of-
for co-warrantor, that will not do. You will have to show that the person does not have a right to hold that post. She does not have the credentials to hold that.
that point I am coming.
That point you come, other point we are not going to agree.
Page 28, same page. Serial number 2, the respondent, date of birth, your Lordship may see. 1/7/79.
Hmm.
As per the advertisement, she should not be less than 40 years on 1/1/2016.
Hmm.
And from this, it appears that she was 37 years at that time.
Hmm.
So she should not be selected for that Lordship.
Okay. Next one. What is the provision of rules for that to that extent?
At page 18, there is an OM. The provision also shows the same. Page 18 also. There are 2, 4.
What is the date of this advertisement at page 59?
That is not available, but the last date of submission was 4/9/2017.
Hmm?
Last date of submission was 4/9/2017, but the date is not available here.
9/9/2007.
Date of interview was 9/9/2007.
Interview was 9.
Last date is 1/1/2016. She was not within the age.
Prescribed the is. Only in 2018 rules, there was a upper age limit
57.
fixed for the 57.
2003 rules, there is
There
nothing.
was not.
But page 18 OM is, and the advertisement also clear also.
Who was the person who otherwise would have been qualified for this post, Mr. Sharma?
If that first one, and if he is not selected, the third one will
The
go.
third one.
Who is that? What is his name?
This is
Third
name.
one is
Anil Kumar Nath.
Anil Kumar. Anil Kumar Nath. He secured 12.
Okay, we will continue. I have some judgments to deliver at 2 o'clock and thereafter we will take up this. The private respondent is not here.
It is not there.
Can you get the judgments with regard to over and to? What to deliver? Mr. Kejriwal, we have accepted your submissions. Some directions with regard to each of the cases involved. We have given it, but you will be getting it only after Wednesday.
Obliged.
Much obliged.
Madam, we have upheld the conviction, but as is normal, we have given them probation. Can't help it. These are cases of 99.
Otherwise, also conviction was very less by the trial.
But now with this 99, we have taken 12 years to decide the
Yes.
matter. I don't think so.
Much.
There is, but the fine and the conviction both have been held. Imprisonment as well. And we have thanked you for your assistance.
Much obliged.
Much obliged.
Dismissed. Dismissed. We have said that the suppression was, it was a malified suppression. Allowed, they will not interfere, and neither they will now disturb the child possession with the respondent number 3.
Much
Petition. We have allowed the writ petition, interfered with the penalty, and also said following the Supreme Court judgment, the show cause is also set aside, and also the period of your suspension will be regularized as on duty, areas to be released. Plus, with regard to your transfer,
Yes, Lordship.
that you approach the authority, whatever they want.
Obliged, Lordship.
Both dismissed.
Obliged.
You're for the APSA, Mr. Doctor, we have recorded name of Ms. Sharma. Not-
No issue, no issue.
Mr. Chaudhary, we have followed the earlier judgment of the coordinate bench, said that in because of that provisions of section 8, that the money will now be released to you.
Lordship.
But anything happens that will be subject to the trial,
Lordship.
but they will not be responsible because this money is being released in terms of the orders of.
Yes.
Both allowed with directions, and ask your daughter and you yourself not to repeat such things
No.
in future.
Never. Highly.
Allowed, we have disposed of, we have said, because we have remanded back the matter to the railways. They will now process and do the needful. We have accepted Mr. Dekka's misrepresentation with regard to the how to do it. We have been misled, we'll say. Just joking.
Obliged.
I am sorry, Mr. Doctor, 10% here, 10% there will not make a difference. We have dismissed the writ petition.
Obliged, Lordship.
Finishing off my long pending errors. Now another 5, 6 are there. That will also be finished. They are having a very high time, bad time. Yes. Fine, money, it was solely a sim. It wasn't Mr.
Well.
I find that respondent number 8 is also represented, but nobody is here.
Yes.
Now tell me,
Yes.
the date 1979
Hmm.
is the date when the lady was, Mr. Sharma, you have done your job. You have done your part. You have done your part. Now 1979 is the date of the birth. So the rule says you should not be below 40 years.
Hmm.
As of 1/1/2016, she admittedly is below 40.
Below 40. That's
One.
happening.
2, she is an assistant teacher. If she is an assistant teacher, she must have 17 years of
Experience as a
She joined the school sometime in the year
1999.
99. She cannot have 17 years of experience as of 2016, 1/1/2016. Okay.
Her graduate scale of pay is 99. 29/11/1999.
99. No, 24,
24/11/1999.
So if it is 24/11/1999, she will complete 17 years of service on 23/11/2016.
16.
So on 1/1/2016, she does not.
Did not have.
So on these two counts, why should we go? We'll interfere. And all benefits will now be required to be repaid.
Not bad for us, but not bad for us.
Seems to be something very beware. Because this is not a point you have raised in your appeal, in
It
your
was-
writ petition.
Yes, that was never.
No way. But it's a point of law.
Because paragraph page 43 are the 4 points of grievance the raised.
I know but that grievance was with regard to constitution.
With regard to constitution and with regard to the
Member not
member,
signed.
member not signed.
That's all.
That
Then
has
he
been
had
dealt
taken
with
up
by
a
the.
plea in the writ petition that 3 names were forwarded, but actually there were 7. That 1
that's
to 3 they
because-
forward. But there is a problem there. The marks which he projects in the 3 you forwarded and the marks that they have got within that 7
Right.
is different.
Is different.
I wanted to see how far Mr. Sharma will go. He has gone now, so I'll have to go with him now.
Yes, true.
Mr. Sharma,
The marks which they have
do one thing. Mm. Item number 9, no? NN Upadhyay, BB Kakoti are the councils who are appearing for the respond number 8. Can you just see whether you can lay a hand on them? You know them?
Yes, sir. I know NN Upadhyay.
You just get hold of him, bring him here so that he also gets an opportunity to make us some. Otherwise, on that point, again, it will come back. So why? Let us see. We are keeping it for time being.
Yes, sir.
Serially matte. Serially. Untu.
May I please, Your Lordship? Lordship,
Any material?
Lordship, in this case, Lordship, the main grievance, Lordship, of the petitioner is that.
Oh, I have heard your grievance.
Lordship,
Now, how do you fortify your grievance? How do you crystallize your grievance?
Lordship,
You say you are the wife,
Lordship,
but there is no material. There is a wife already who is receiving the pensions.
Lordship,
1. 2, you are a Christian.
Lordship,
So you can't have a second wife without divorcing the first wife.
Lordship,
So the second marriage admittedly is not permissible. 3, the children are all the daughter, son who has been projected. He is above he is a major. So he is not entitled. So nobody is entitled. And you have not even taken the pain of filing a reply to the affidavit filed by the respondents. Detailed affidavit. So this court is left with no other alternative but to dismiss it.
Lordship, the welfare officer, Lordship,
So welfare officer, forget it. We have the army authorities coming and filing affidavit. You have not disputed that position. Where is your marriage certificate, by the way? You have only a panchayat certificate. A Christian marriage cannot be taken place in
next
that.
of kin certificate is there, Lordship.
Huh?
Next of kin certificate, page
Oh,
13.
next of kin is an affidavit certificate. And you filed an affidavit, they gave you.
Okay.
And see, the husband, while he was in service, made the nomination in favor of what that lady's name is,
Swapnis or Malak.
Swapnis R. Marak.
Okay.
Even when he retired, when he was sent out,
Lordship,
that time also he made a declaration and same, the wife was, same thing.
Okay.
What do you propose? If I dismiss it, it would be the end of the matter.
Lordship may direct the respondent, Lordship,
We are not done.
to consider the.
You will have to go to the civil court, establish that you are the wife entitled, there is no other wife, and then proceed. If you want to withdraw the writ petition on that lines, I'll not come in. Otherwise, I'm dismissal. I can't help it. In view of this material that has been brought on record, I'm left with no other option. The only way I can help you is you withdraw the writ petition, you confer with your senior.
Lordship may allow
After some time, I'll take it.
Deeply.
Tell Mr. Chaudhary that this is the position we are not.
Okay.
You confer.
Deeply.
I'll let Matidi by it. When you are ready, you just come and tell her. Mr. Tan.
Lordship, on 6th, we received 6th or 7th, Lordship, we received one letter from the AG's office, Lordship. They have requested us to submit the pension proposal, Lordship.
We have directed that.
Yes.
On 23/3.
Today morning, I talked to the officers, Lordship, and they informed me that they have already collected all the necessary documents from
This is not done.
I mean,
This is not done.
it was earlier
Right,
returned.
this is not done. Because everything was ready. The second marriage thing was objected to by the AG office. We came in and said, okay, show us how the proceeding is to be now done
Yes, Lordship.
with regard to a dead man. Then Mr. Talukdar said that let them send that back to us. We will do the needful.
Yes, that.
Now, why this was not sent then till today?
Lordship, initially, Lordship, it was rejected by the government actually. Government rejected, then it was forwarded to the AG, then AG returned, Lordship. Now it is for resubmission, Lordship.
Show me why, after the government had rejected,
Yes.
how it was sent to the AG?
No, thereafter it was sent, Lordship. Initially it was rejected.
So you have prepared the pension proposal.
No, after its rejection, Lordship, it was sent back to the office of the executive engineer, I think, Lordship, lower office, Lordship. Now they are collecting all the documents. Lordship.
Why? Where is that proposal gone? Where is that proposal which was reverted back by the AG gone?
No, that proposal we cannot forward, Lordship, as it is, Lordship.
Because why
to
you cannot
resubmit.
forward for that?
We have
The
to- we have
documents
to-
only, the documents would be the
Lordship,
same.
it will be only a question of 10-15 days, Lordship. In the meantime, they will.
This is not done. We had made it very clear. The pension proposal with regard to a lady, and the man had died in 2008.
8, Lordship.
And from that date till today, it has been pending.
Yes, Lordship. I understand that, Lordship. But I'm
Now,
pretty.
I can't prepare the proposal, or I would have done it myself. That jurisdiction is not with me. These cases, only on that count.
In fact, Lordship.
Second marriage.
In fact, Lordship, I have already.
Mr. P. Naik, Learned Counsel for the Learned Additional Advocate General appearing for the state respondent, submits that the proposal is at an advanced, the pension proposal in respect of the petitioner is at an advanced stage and would be forwarded to the Office of the Accountant General on or before 15/5/2026. This court had, while order dated 23/3/2026, required the authorities in the Public Works Department to forward the pension proposal of the petitioner to the Office of the Accountant General, bracketed A&E, Assam, within a week from the date receipt of the certified copy. So, however, considering that the matter is under process and the delay occasioning in authorizing the pension and pensionary benefits of the petitioner can be redressed by imposing interest on for the delay so occasioning, this court permits the respondents in the PW department to forward the pension proposal to the Office of the AG A&E within on or before 15/5/2026. Registry to list this matter again on 20/5/2026. Mr. Naik shall apprise this court as to the development taking place in the matter
Yes, Lord.
after passing of this order. Also, registry to list this matter again on, it was in a 25 for further hearing. You wait, man. If there is some more delay, we will redress that
Lordship,
with
Lordship,
interest.
I will make it confirmed, Lordship.
We'll make it by interest. 2008 onwards. And this interest will be on you also. Headman, you want to proceed, this is not done.
Obliged, sir.
Yes, Mr. Soikia, by mistake or by?
Absolutely on time. Next
Item-
item is ours.
11, ORIP, regularization. You are for oil.
I am for Oil India. ONGC.
ONGC. Yes.
My lord, the petitioners, they were appointed during the period of 85.
No, I got it. Those things, much water has flown.
My lord.
Now, the court said to trial, the labor code or the
Industrial
the CGIT
TGI.
had asked for your regularization, to continue till 60 years
My lord.
with all benefits.
My lord. Not with all benefit,
The benefits that is permissible.
not benefit, this may be substantially increased because they were drawing 15,000.
Now, what is your grievance? You want regularization. But that regularization that was directed by the Supreme Court was in a particular circumstances. Do you come within that?
Yes, my lord. That is the case, my lord. Sure. That is the case, my lord.
The only thing is that I am a little bit handicapped because Annex, he could not reach Gauhati. He is in Imphal.
Okay.
Could it be taken on any other day?
Whenever it's convenient.
Because some factual things he have to brief me.
Okay.
My lord, my
On
lord,
Tuesday next hour.
my lord, matter may take some time. May I say something to say something, not finishing.
No, please, Mr. Bhusan. Always welcome.
My lord, kindly see, I have gone through the total whole records, my lord. The judgment passed by Honorable Justice Jain Sharma covers everything, my lord. And I want to read this judgment, my lord. Not the whole part, only the operative findings of fact, my lord.
Page, that means you want to come to
Page, my lord,
conclusion of.
page, my lord, 31.
And this is one of the judgments that I found have gone to around, it's around 18 pages, 19 pages,
My lord.
which is not the normal thing with my Lord Justice Sharma.
My lord, my lord,
4 or 5 maximum.
my lord, honorable court has recorded here that I have personally gone through the records to find out the fact. This is in the judgment, my lord. My lord, I am coming to the operative part only. I'll come to page 42, man.
Page?
42. 42.
Yes.
Paragraph 5A. The honorable court has recorded the findings of the tribunal. So that we need not go to the tribunal again, my lord. We can understand the facts from here. The tribunal's consideration that the main question to be decided is whether the concerned workmen are casual workers or contractual laborers. The tribunal, considering the statement of the witness of the union and Exhibit 8, found that the ONGC issued a transfer order transferring an employee from the DSA 1 department to so-and-so department. Exhibit 5 and 6 show that the DVP started functioning in the year of 1981, and appointment letters Exhibit 5 and 6 were issued to 2 of the concerned workmen, that is Gajan Murmur and Provincial. I find that all the concerned workmen are not contractual laborers as claimed by the management. Further, I find that no work order were issued prior to the demand raised by the union for a regulation service. The management witness L. Kosari admitted in his cross-examination that payment of wages of the all concerned workmen is made under the clause A19(1). AVP management considers all workmen as contractual laborers. Exhibit 2D and Exhibit E2 issued by the management shows that payment has been made to casual laborers. These exhibits clearly prove that the management makes payment to casual laborers and not to any contractual hand, my lord. My lord, these are the finding of fact, my lord. Dhansiri Valley project is a temporary project, but a permanent one, and Dhansiri Valley project has started construction of oil near Jorhat, which will the future headquarters of Dhansiri Valley project. Exhibit 13 is the site plan and the map of the state town near Jorhat. My lord, then.
But this was then taken up on appeal.
My lord.
This was taken up on appeal.
No, this was
not essayed.
At that time, provision for appeal was not there. It was directly challenged by the ONC before
the Supreme Court.
Supreme Court. And Supreme Court has, my lord, dismissed the SLP.
Dismissed this.
Therefore, a finding of fact recorded here in these judgments are most relevant finding of facts. And in between, there is judgment of the appellate court in the second round. My lord, with my most respectful submissions, the judgment is a nullity in the eye of law.
Because see, I am a puny judge here. How can I go beyond my division bench?
No, this is only my, I have my understanding.
You can say
my understanding, my lord. My understanding, my lord. Sure, my lord, this judgment.
Because what has happened here, that reference that was finally decided.
My lord.
By my Lord Justice Sharma.
Yes, my lord.
Went to Supreme Court.
Yes.
SLP dismissed. Then the second round, the appellate body had remanded the reference back to the industrial tribunal. Right?
Right.
Then the matter was again adjudicated there.
Adjudicated.
And then this proceedings have come up.
Yes, my lord. But only one line, ma'am. One line. Please don't mind, only one line.
But Mr. Goswami.
Yes.
Rightly, wrongly, that order is there. Have you assailed this order before the Supreme Court?
No, I was not there at that point of time. I would directly advise them. But I was not there at that point of time.
But this order having been complied with,
my lord,
that direction having been complied with,
my lord,
we will now have to look into the matter from that stage only.
That's true, my lord. That's true, my lord. And I'll come to the judgment also. The judgment has also, division bench appellate judgment has also given us protection, my lord.
Protection, but
Yes.
the thing is, it was remanded back
Remanded back with protection, my lord.
till that
Yes,
stage when the matter is
yes.
finally okay.
Yeah.
We'll have it. We'll have it.
My lord, only
We
one,
got a hang of it. We'll have it.
only one line, my lord.
Hmm.
Only one line. Page 45.
45.
Yes, my lord. Look, I wasn't.
Hmm.
Roman 3, first line.
Hmm.
Honorable Justice Jain Sharma has recorded it. The name, designation, verification, and date of appointment of these workers are at Annexure 10 of this affidavit in opposition, my lord. This Annexure 10 is again we have proved before the
Before the thing.
before the CJ.
But the only thing is, all this have gone. Now the tribunal has come to a different conclusion.
Yes, my lord.
So you will have to argue on that the conclusion is perverse.
Yes, my lord.
Actually.
One more submission, my lord. The whole case, if you put Honorable Justice B.K. Sharma, who has the directed regularization of these employees in that judgment, my lord.
But that is the judgment which has gone up on appeal.
Appeal, my lord. The judgment, my lord.
We'll hear it.
Yes.
Give a date convenient to both of you. If possible, just leave the next week.
Okay, Lordship, in that case, 14th,
14, fine.
14th is Thursday, yes.
Fine.
My lord,
Fine.
my lord, only short prayer, my lord. Since my lord has gone for the records, my lord.
No.
Oh.
But as agreed to by heard Mr. S.S. Goswami, Learned Counsel for the petitioner, and Mr. D. Saikya, Learned Senior Counsel, appearing for the ONGC respondents, assisted by Ms. P. Burua, Learned, assisted by Ms. P. Burua, Learned Counsel for the so and so.
She is a standing counsel.
Standing counsel, ONGC. So, as agreed to by the Learned Counsel for the parties, registry to list this matter again on 14/5/2026 as a top of the list matter. So,
Lordship.
Thank you.
Highly obliged.
and Mr. Soikia, see, they are there with you for a very long
Our
time.
hands are tied because of the division bench judgment. It has been. Anyway, Lordship, I'll make my. That's what I have already instructed Mr. Annex also. Like,
If you can do it for thousands in Upendas, why not for a few here?
My lord,
no, Upendas is Assam government. This is ONGC, Lordship.
my lord.
Assam government is very
But the
liberal.
common factor is Mr. D. Gugui. D. Soikia.
No,
The common factor is Mr. D.
I'll try my best. I'll try my best.
My lord,
Something of that
Lordship.
thing that they are there, they
Lordship.
get something.
No, Lordship. I'll definitely make my efforts.
my lord, I have seen the senior advocate has big heart and
Oh, he
big heart,
Big
and
heart.
big heart and big
accepted.
my lord.
Accepted.
No, it's a fact, my lord. He's open to all.
I
Accepted.
think I have to withdraw from this case now. Deeply obliged.
The fight he puts up does not show that the big heart. He has a big heart, but that fight he puts up,
No,
that
you-
does not demonstrate that big.
A big heart, but
Yeah. Oh.
If I may be allowed to withdraw.
Heard Mr.
I.U. Chaudhary.
I.U. Chaudhary, Learned Counsel for the petitioner. Also heard who was there for the respondent? Mr. C.K.S. Burua, Learned CGC, appearing for the respondents. The petitioner in the present petition has prayed for a direction upon the respondent authorities for being authorized a family pension in respect of the service in pursuance to the death of her husband, late husband Cleaver A. Sangma, who was a ex-serviceman and discharged from his duties on 1/4/1990. So the respondents has filed an affidavit in the matter wherein they have brought on record that the husband of the petitioner had nominated one SWIPINISHR Marak as his wife and nominee in his service role, as well, which was also reiterated at the time of discharge of the petitioner. Also, the service records of the husband of the petitioner projects that does not contain the name of the petitioner as his wife. Also, the said position was not disputed by the petitioner by way of filing an affidavit. Also, today, when the matter was taken up for a hearing, Mr. Ayur Chaudhary, learned counsel for the petitioner, after attempting to argue the matter at some length, has prayed that he be permitted to withdraw the present writ petition with liberty to approach the competent court of law for establishing that the petitioner herein is the wife. To enable the petitioner to enable the petitioner to establish that she is the wife of late Cleaver A. Sangma, and that she is entitled to be authorized a family pension in pursuance to the death of her husband. So, prayer is not objected to by Mr. C.K.S. Borua, CGC, appearing for the respondents. Accordingly, the present writ petition stands dismissed with liberty as dismissed on withdrawal with liberty as prayed for. With liberty reserved to the petitioner as prayed for. Mr. Chaudhary, what are you waiting for?
I have been forced to come, my lord. 14, my lord. Top of the list, cause list, my.
Okay, yeah, 14 today.
This is regarding.
The respondent, have you informed? You are appearing?
Respondent number 6.
In this case, we have filed a written
Mr.
argument.
Chaudhary is there for respond number 7. K. Chaudhary.
Has to be another date.
So I had been forced to come by somebody, my lord. You
Right.
also understand, my lord. But
Nowadays, there is waterlogging in deserts also. Yes.
in this case, once, but when argument concluded, we filed written argument. also.
I've seen it.
So anyway, Mr.
Not a big issue, small issue. We
Small
can
issue.
consider. You want it to be considered today or
No, any day, my lord.
on the
Today,
prayer?
my lord, we are
Just
busy for.
inform the other side also.
Yeah.
On the prayer of the learned counsel for the
pleadings
registry to list this matter again on when?
Pleading complete, my lord.
Everything is complete. We are taking up.
I think we have to just, both the side have to make the slight argument for your lordships note down. Otherwise,
This issues are just
Yes.
the issue you
Yes,
argue,
there is-
we will proceed. When? Tell me.
May, my lord, first or second week,
my lord, either 12th or 14th, any day,
19.
19.
19th. Okay.
Comparable.
Good.
Ask Mr. Chaudhary also. If there is any problem, tell her.
Shahjahan.
Whoever is.
Yes.
My lord, only thing, endeavor for disposal on that day.
It would be any matter in the top of the list is for disposal.
It will remain on the top of the list, my lord.
No, as a top of the list.
My lord, obliged to us. Obliged.
Deeply obliged.
So what does have receded? Mr.
Yes,
Abedin,
it's the front gully other than my lord where used to stay.
I know. I can presume the water level in your place. Maybe in the first floor also it was.
No, no, no. No, it was ground floor and
Ground floor.
even the rickshaws were not allowed.
Oh, yeah. Accepted.
But he is here, my lord, that I.
For item, respondent number 7.
Because Mr. Chaudhary has now been brought in.
Yes, ma'am.
So he wants to just accommodation. We are fixing it on 19th. No problem.
My lord.
19th.
Deeply
19th.
obliged.
Obliged.
Please, Your Lordship.
Just a moment, just a moment, just. Yes, who is appearing for the respondent?
I'm appearing for the respondent number 6. Lordship.
6. Okay. Okay.
My Lord.
You have argued that, first point, that her date of, his or her, or his date of, respondent number 6's appointment date
Yes,
is 2011.
2011.
After 1/1/2011.
My Lord.
But their projection is that they were appointed in pursuance to a managing committee resolution of 2010,
2010.
prior to 1/1/2011.
Yes.
What is the material to demonstrate that?
My Lord.
What is your material to demonstrate that he was appointed in 2011 and not 2010?
2010. My Lord.
Madam, have your sit.
Yes.
We are taking it up for final disposal.
My Lord, I will take up to this, my Lord, that the material as your Lordship asked for. But before that, my Lord, even if, my Lord, it is assumed that the date of
No,
appointment.
first you show me,
My Lord.
because it's your clear case, your
Yes.
your categorical case.
My Lord.
Show me that.
My Lord, Lordship may kindly turn the page 18, my Lord.
18.
15.
1A.
1. It is 17 on page 17, my Lord, that is the, my Lord, translated copy, type copy, my Lord.
17.
17, my Lord.
Hmm.
That is the proforma, my Lord, called for by the, my Lord, concerned authorities to, my Lord, for determination the experience in the year 2010, my Lord. On that, my Lord, table, my Lord, the respondent number 6 is Devananda Bora, my Lord.
He is 13/7.
13/7/2011. My Lord, his experience, Simon.
Okay, where is your corresponding statement to this
My Lord.
in your writ petition? Annexure 4.
Next up. Next, sir, it is on page 6, my Lord. Page.
Has this been dealt with in the affidavit filed by the respondent number 6?
No, my Lord.
And with regard to the affidavit filed by the others have not filed any affidavit here.
My Lord, the private respondent number, that my Lord, and my Lord, the deputy commissioner has, my Lord, submitted a letter before this honorable court. As per that letter, my Lord, they have made an inquiry. As per the inquiry, my Lord, they have found that, my Lord, the date of appointment of the private respondent number 6 is 13/1/11.
Where do I get that letter?
That is, my Lord, that was reflecting in the order, my Lord. That is order of 17/3/2025, my Lord.
The initial disposal order.
My Lord, honorable court's order, my Lord, that is on para number 6.
Okay.
My Lord, another thing, my Lord, and that the IS also, my Lord, he
Has written 18/5/2023.
my Lord.
But before the tribunal,
My lord.
the departmental authorities had taken a totally different plea in the affidavit filed, in the written statement filed by them.
My lord, an inquiry report was submitted.
In the before the tribunal?
Yes, my lord.
Where is that?
That my lord will find on page that starts, my lord, relevant portion, my lord, will page 20, my lord.
Of your writ petition?
My lord, my writ petition. 4, 5. My lord, the complaint was there. My lord, the para number 6, my lord will
No,
find.
no, I'm not on that. Somebody has brought on, there is something here, yeah, who has brought it? Devananda Kumar. He has filed an affidavit and therein he has brought on record the pleadings before the tribunal. Right?
My lord.
Now you come to that a page, starts at page 49.
Page 49.
Now, who is 129 before the tribunal? Director, deputy director, commissioner, 10-9. And therein, come to page 51.
51.
Para 12.
Just before the scrutiny committee, Devananda Borua has been working since
13-10-2010.
2000. Yes,
So
my
this is the stand taken by the
headmaster.
by the then district elementary education officer. Not the so disputed question is fact is okay. We presume that she joined on that day.
My lord.
Then what?
My lord, then also, my lord, the petitioner is 12 years senior to the, my lord.
Okay, let us come to the. Where was that chart you showed me now?
My lord, that chart, what you will find on page, my lord, of page 17 of my writ petition, my lord.
So you are also a science teacher.
Yes.
Devananda Bora is also a science
Science
teacher.
teacher. DSC, both DSC.
So you say because of the seniority, you should be given.
Yes, my lord.
And why Devananda Bora was appointed?
My lord, Devananda Bora was appointed
13-10-2010.
Let
Come to page 26, para E.
that in the knowledge information on who has been appointed as science teacher in the school on so and so. Abul Bora has been appointed temporarily as science teacher in place of Jitu Bora as the letter went to complete graduation.
So
Jitu Bora joined his service. Babul Bora has been posted as assistant teacher in the school.
Madam, have your son.
Jitu Bora resigned from the post due to his appointment as so and so, so and so, so and so. Doing job to invite application. Okay. My lord, he has been that maybe, my lord, but he was appointed.
Mr. Das,
My lord,
the rule says
my lord,
mathematics and science,
science,
right?
right,
You are a combination.
my lord.
You don't have mathematics.
My
You
lord,
cannot teach mathematics.
my lord, the rule says sciences.
Ritu Bora was there who was teaching mathematics,
My lord,
right?
right,
Ritu Bora went,
exactly, my lord.
maybe you have been accommodated, but they found that they wanted a mathematics teacher. So he has royal combination.
My lord,
He came in.
my lord.
Why will he not be appointed?
My lord, as per the, my lord, prevailing rules, the qualification required for a, my lord, science teacher is, my lord, BSc. BA, my lord,
You can't have further breakdown.
my lord,
You can't have further breakdown with regard to the subjects you have.
my lord, BSc is required.
BSc Bio, BSc Royal, everything is
My
same.
lord, yes, my lord, everything is same. There is no any differentiation in the, my lord, that as per the prevailing norms regarding to the qualification, my lord, it was not differentiated. It is, my lord, BSc and 2 years DLR course is required.
There are decisions of this court on this point. Have you the decisions?
Lord, regarding this, my lord, Royal and Bio.
That you can't make distinction between Royal and Bio. BSc only.
BSc.
This is your case basically.
Basically, and my lord, data part with all due respect, my lord, there is a provision under this, my lord, the section 7. If my lord, tutor is not fulfilling the requisite qualifications, there is 5 months. My
Oh,
lord.
that. Yes, ma'am.
Respondent number 6 is joining date 13/10/2010. After the managing committee,
We accept that. You joined in 2010. No issue. Now tell me.
about the regarding date of the joining of respondent number 6, there is an affidavit filed by the DEO.
Madam, I am accepting that you joined in 2010. No dispute.
Yes.
You joined on 27, uh, Thirteen 2010. We
Yes.
accept that.
Yes.
He is also a science teacher.
Yes, Lord.
You are also a science teacher. Now, who is senior?
Lordship, as per the section 311, clause 11, Assam Education Professionalization of the Service of Teacher and Reorganization of the Education Institute, mathematics subject is required, Lordship.
He can teach mathematics.
Lordship, we have a biology.
That cannot be. That cannot be.
Lordship, the petitioner, when the petitioner joined as a temporary science teacher, one Jitu Bora, he is appointed as a science teacher, and he is on leave for he completed the for his graduation. And after that, he rejoined in his post. And 3/6/2010, Jitu Bora resigned from his post due to his new appointment in the health department, Lordship.
You are not still on the point. 311 will not help you. There is some other provision in the rule will help you. Act, sorry. See 3(8), Roman 8, 3 Roman 8. Section 3, Roman 8. Oh dear. Where is your higher secondary, matricular higher secondary mark sheet?
My lord, that marksheet, my lord, I have not annexed, my lord.
You passed in mathematics.
That cannot, I cannot ascertain.
You have not disputed that position. You're like me. Your client is like me. Plucking in mathematics, it became fourth paper.
My lord, that has to be brought in.
Yes, Mr. Fukon.
Rules may not be the argument which you have made, my lord, regarding mathematics, my lord.
I can't make any argument. That's the problem.
The
Hmm.
I also give you my lord.
There has to be a teacher who will teach science and mathematics. Now, the projection of the respond number 6 is that petitioner had failed in mathematics. Now, the only thing that can save the petitioner is that the respondent number 6 was appointed after 31/12/2010. And how does your authority say that she joined in 13/10/2010? Her name is in the, her name is in the dice data of 2011,
No, my lord.
2010.
No, that is not there, my lord. That is.
Yes, madam, why your name is not there in the dice data of 2011?
That's the, yes, my lord. that
If
is-
you have joined in 2010,
Exactly, that is not there.
can somebody get Mr. B. Chaudhary? Mr. B. Chaudhary.
But with all due respect, my lord, earlier, so far as I remember, my lord, record was for, my lord, it was written but reverted back. There, my lord, it was observed, my lord, that her name was not there, only inserted in the year 2012. My lord.
We'll have madam, your name is there in the dice data all along.
Lordship,
Dice data. Mr. Fukon, if his name is not there in the dice data, how did your SLC, your joint committee, find that she is working in this school?
That my lord, the SSA has to.
No. How did you? Oh, forget it, SSA. You made the scrutiny. I find that in cases you ask the SSA, give us data, name is not there, immediately your joint committee says, don't proceed. Now, why did you proceed in the case of the respondent number 6? Or is it that the procedures are flexible? On the basis of case law, whoever comes, you can modify it. But the learned counsel for the parties at some length. Mr. A. Fukon, learned counsel appearing for learned standing counsel, elementary education department, shall place before this court the materials basing on which the district scrutiny committee, state level scrutiny committee,
My lord, it's the level.
had processed the claim of the respondent number 6. It is found that from the materials available on record that the departmental authorities are projecting that the petitioner, respondent number 6, was not appointed in the school on 13/10/2010, but was so appointed on 13/7/2011. Also, further, the dice data that was procured for the purpose of the teachers of the school, dice data of the school that was procured for the purpose of processing the claims of the teachers of the school for provincialization of their services shall also be placed on record along with the resolutions of the DSC as well as the SLC. Registry to list this matter again on (13/5/2026) as a top of the list item for further hearing. Let these materials come, will come, because now the division bench has asked us to determine the seniority. So we'll have to determine the seniority. We'll do that.
And then Senior has come. May I please, Your Lordship? I'm appearing on behalf of respondent number 8, but we are no more associated with this case.
Okay, fine.
And that has already been intimated to the client, Lordship.
Okay, fine. We'll say none has appeared. Anything more? Nothing?
No.
We'll have to interfere. Where is Mr. Kaushik? B. Kaushik. Okay, you can leave. Let Mr. Kaushik come, we'll pass the arrest.
Lordship,
When is your date of retirement? When will you retire?
perhaps it's an
Okay, what is your instruction?
instruction, Lordship, they say that they generally follows the SAD rule 1963, Lordship. And
So how was the person appointed and continued, regularized, paid?
Lordship, they says they don't have the record at this.
Okay, how is he being paid his salaries? How are you paying his salaries?
Lordship,
SAD is not paying.
yes, we are, Lordship, yes,
SAD is not paying. So irrigation is paying.
Lordship,
So
Lordship.
promote him. You promote him.
Lordship, if we have to promote, Lordship, then, Lordship, we have already stated in our instruction, Lordship, that there is no grade 3 post in our irrigation department in the
Bring him
secretariat.
to the office of the chief engineer. Now the chief engineer and secretariat same. So bring him to the chief. Is inquired from the petitioner. Is this the condition you are now in?
Lordship, they have to, in fact, Lordship, to confirm it, Lordship, whether they also inquired the petitioner, Lordship.
They said as.
No, this is a language, Lordship, but they also, I have to talk with them, Lordship. They also inquired with the petitioner, Lordship. In fact, it should be there also, Lordship.
So promote him. From the date others juniors to him in the secretariat service was promoted. With all consequential
There are
benefits.
4 persons in the department, there is no post, Lordship.
I can create a post, supernumerary post. Create supernumerary post. Or assail my order before the division bench, nothing like it.
Only thing is, Lordship, if the department it says this follows these particular rules, Lordship.
How is his salary is being paid? From which account?
That instruction I have not obtained, Lordship.
Then you
Well-
call your secretary, we'll discuss with him.
Lordship, no, Lordship.
Daily
Yes,
we can't.
No, Lordship, what happened, Lordship? I can just call him,
call.
No, Lordship, over telephone, I'll take the instruction.
Okay.
I'll take the instruction, how who is paying this.
Ah.
Just 5 minutes, Lordship.
Fine.
Please, Your Lordship, matter will be take after some time, Lordship. Senior air who is arguing another matter
Oh, he's too busy. It will be very difficult for him to come.
after some time, Lordship.
Among 92 rules to the Hey, the rule. Another issue. Okay. We'll not pass any adverse order. Don't worry. Till Mr. Bhuya comes. It's a matter of 21 just lying here.
Lordship.
Yes, Mr.
18/11/2025, Lordships, I was directed to obtain some instruction. I have received the instruction.
What is the instruction you wanted? Do you want it?
My lord, that Lordship may kindly goes to the order dated 18/11/2025.
What is this 5937?
That already been disposed of.
Okay, those two candidates
Lordship,
who had
Lordship.
gone up on the division bench also.
Lordship. And even then, Lordship may kindly see the third para, Lordship.
Of the first page.
Second page, Lordship. Order to name. No, I ordered to. Oh, he's speaking. It doesn't matter.
Our candidate.
Mm. Where is the recent Lordship?
Yes, Mr. Bhuya, what is your case?
My lord, my case is that, my lord, an advertisement had been floated for the purpose of, my lord, recruitment of the recorder certificate class force training. That is, my lord, frequently we term this as a mandals, my lord, for the purpose of sending them to the training. Now, my lord, I draw my lordship's attention to the advertisement, my lord, is at page 34, dated 27/1/2020, my lord. And in this advertisement, my lord, the condition and the rules which has been fixed, my lord, nowhere says that the reservation criteria will follow. Because, my lord, this is not under the Assam Scheduled Caste or the Scheduled Tribe Reservation of Vacancies Act. This is only for the, my lord, training purpose. That's why, my lord, there was no condition. Now, my lord, when we responding to this, my lord, we did participate. Call letters had been issued as an open category, general category candidate to both the petitioners, my lord. And accordingly, my lord, the select list had been issued. My lord may be pleased to find the first select list at page 42, my lord. The list of successful candidates, my lord, undergoing the recorder certificate class course training. Herein, my lord, the name of the present petitioner had not been reflected. If my lord may be pleased to take up the remarks column, herein, my lord, we have found that the unreserved, the roster point had been, my lord, applied. Unreserved, OBC, and the, my lord, these all reserved category candidate had been selected. Now, the list of unsuccessful candidate, my lord, may kindly turn to page number 44, my lord. My lord, the serial number 4 is the petitioner number 1. My lord, the total marks, grand total, I have received, my lord, 86.67. And my lord, the petitioner number 2, who is at serial number 2, my lord, have received 88 marks, my lord. So now, my lord, if we come to the list of successful candidates, we, my lord, as a general category candidate,
You
my
come
lord,
in.
we can, my lord, be inducted. Now, by virtue of the reservation, my lord, we have been ousted by applying the same.
Okay.
So, my lord, our contention is that the game or the rule which has been fixed, my lord, had been subsequently amended, modified or altered, my lord, which is not permissible, my lord. Number 1. Number 2, my lord, as the reservation law is not applicable for the purpose of training, so it was a conscious decision on the part of the government that we will not follow the same.
What, any decision to support your submission?
My lord, this submission to support my decision, my lord, today I am, my lord, with a single honorable, my lord, single judge order, my lord, wherein exactly the similar issue has been taken care of. If my lord may be pleased to take up, my lord.
What is the case number?
The Dipankar Majumdar and another.
Yes, I have the.
5937, my lord.
I have the, it's on record here.
My lord. So, my lord, hearing exactly.
I think this was taken up on appeal and the appeal also was dismissed.
My lord, by the state, my lord. So, my lord, the law is well settled and my lord covered the same, my lord.
Okay.
Same judgment, my lord.
Okay. This is a decision. Now, Mr. Bhuyan,
My lord.
the advertisement not having prescribed a reservation.
My lord.
If the reservation is prescribed in a rule, will that be enough or it is also not proper?
No, my lord, if it is in the rule, my lord, then the issue will be, my lord, different, my lord, because
How
that,
different would it be?
my lord, the different it would be, my lord, because the rule is a, my lord,
That has to be
arising out
followed.
of a, my lord, has the
Even
force.
if it is not disclosed in the advertisement,
Affidavit,
the
my
rule
lord.
has a.
Yes,
That
yes,
has
my
to
lord.
be followed.
Now, my lord,
Now, the
now,
whole thing is covered by a rule of 1992.
1992, my lord, the regarding training rule, my lord.
Training rule.
My lord, my lord.
And
But that is
read
not
that
the,
rule.
my lord.
To read that rule. If you read rule 20,
My lord.
5,
20.
sub rule 5, take this.
I have a copy, my lord. Yes, my lord. Rule 20 says, in admission into each course, the director will invite application from intending candidates, preferably by the middle of June of each year. Before the final selection is made for admission to the course, the director will obtain a statement from the each district in regards to the following. Reserved, clause 5, my lord. The reserved vacancy and backlog position regarding the scheduled tribes, plain tribes, scheduled caste and other backward classes in the districts and subdivision. And in making the final selection, the director will pay due regard to the need of the districts.
So,
My lord.
if it is only done by merit,
My lord.
this aspect was not brought to the notice of the coordinate bench, neither to the notice of the division bench.
Division bench, my lord.
Now, if a recruitment for Mandal
My lord.
is to be made, and the training is only by way of merit, no scheduled caste candidate, tribe candidate, no scheduled plain candidate, maybe a few OBC community candidates may come in. The others will not come because now the selection will be notified by the recruitment will be notified by the concerned deputy commissioner.
My lord.
So the person who apply, there are 10 posts, 3 are reserved for, 4 are reserved for reserved community candidates.
My lord.
There will be no one. So that is why the rule has said, while you make the final merit list, incorporate this. And they have done it. What is the error?
No, my lord, my lord, my understanding, my lord, is that the reserve vacancy and the backlog position regarding scheduled tribes, scheduled caste and other.
That is, Mr. Thing is that in the district, if there is say vacancies and a backlog position.
My lord.
That has to be communicated
Yes, yes.
so that
My lord.
while preparing the list for Kachar,
My lord.
this can be provided for. That's
My
all.
lord. My lord.
Whether it is legal, whether it is illegal, no challenge to this.
Normally, the rule which they have made, my lord, today it has come to my knowledge, my lord, for the very first time, my lord. I have not.
Oh,
My lord.
Via is 5 minutes. You can get it.
No, my
You
lord.
take it up after some time, you go through it.
My lord, next Tuesday, no, my lord. My lord, may keep it as a part third, my lord. Part third, my lord.
Part heard, non-part heard, nothing.
Because,
is
my
there.
lord, we are, my lord, being, if we go by the merit, my
And
lord,
now I can't even direct because by now the whole scenario has changed.
No, that is, my lord, that is also one aspect, my lord, because the rule of recruitment or the training has also
Everything gone.
has been changed. Now graduate degree is a mandatory degree now.
And you don't have that.
No, one petitioner have one. No, my lord, one petitioner have and another do not.
No, now it is not a training. Now it is appointment.
Then training.
Then training.
Then training. That is correct, my lord. Now, no, my lord, we are on the issue that when the advertisement was issued, whether our rejection or the outstar was in accordance with the law or not. My
That
lord.
was
So
I'm
therefore,
telling
my
you.
lord-
Your only ground is that they could not have made provision for reserve community.
My lord.
I'm showing you the law.
No, my
20.
lord, this law, my lord, just, my lord, a few days, one day, my lord, maybe please be given, my lord, I will.
But Mr. A.R.
Right.
Bhia, learned counsel for the petitioner at some length. Mr. Bhia submits that he would make his further submissions in the matter after perusing the provisions of the Assam
Assam, my lord, Survey and Settlement Training Central Rules, 1992, my lord.
Assam Survey and Settlement Training Center
Central
Rules
Rules.
1992. So prayer is not objected to by Mr. J. Handick, learned counsel for the learned standing counsel, revenue and disaster management, appearing for the respondents. Raised this matter again on 25/2026 for further hearing.
My lord. Highly obliged, brother. Okay. Obliged.
Amen. Yes.
Compensatory appointment matter, person was died in the year 2005. Why it's 21 years.
Died in?
There is a order of the Honorable Court, the basis of which I am coming and the lordship. Your lordship come to page 46.
Then I have received instructions, your lordship.
60.
No, 60.
What happened for 5 years after 2012?
There is no answer, Lordship.
But Mr. Ashram also heard Mr. N. Upadhyay, Learned Standing Council, Litigation Department, hearing for the respondents number 1, 4, and 5. Also heard Ms. S. Borua, Government Advocate, appearing for the and the petitioner in the present petition has prayed for a direction upon the respondent authorities to consider the case of the petitioner for appointment on compassionate grounds and for the purpose to set aside the order dated 24/10/2012 passed by the Executive Engineer, Mangalore Division, Irrigation, Mangalore, communicating, rejecting the claim of the petitioner for appointment on compassionate grounds. The father of the petitioner, while working, father of the petitioner, Pradip Kumar Das, while working as a regular driver in the office of the assistant engineer. Assistant Executive Engineer, Tangla Subdivision, Irrigation, under Mangalore Irrigation Division, tied in harness on 10/7/2005. It is projected in the petition that the petitioner had thereafter submitted an application for consideration of his appointment on compassionate grounds on 19/1/2006. So, the said application of the petitioner was placed before the jurisdictional district level committee in its meeting held on 15/2/2007, 19/5/2007, and 19/5/2007. However, the case of the petitioner was not considered for such appointment. Being aggrieved, the petitioner had approached this court by way of instituting a writ petition being WPC number 2660/2007, and a coordinate bench of this court-wide order dated 10/9/2007 proceeded to direct the respondent authorities to place the case of the petitioner before the constituted committee for consideration of his case.
This order was received lately because they are from before that, in the year 2014, the petitioner filed one writ petition again. It is a
2007, we see. We are only in 2007 now. We are going to 2000. Consideration of the case in terms of the guidelines laid down. So, it is further projected by the petitioner that in the subsequent meeting of the jurisdictional district level committee held on 15/2/2008, the name of the petitioner was again not considered. So, the case of the petitioner was also not considered in the manner required in the meetings of the jurisdictional district level committees held on 29/4/2008 and 12/6/2008. Also, the petitioner being aggrieved by the non-consideration of his case for appointment on compassionate grounds, the petitioner again approached this court by way of instituting a writ petition being WPC number 3961/2012. Coordinate bench of this court-wide order dated 21/11/2014 proceeded to dispose of the said writ petition directing the respondents to consider the case of the petitioner strictly a petitioner in terms of the decision of this court in the case of Achyut Ranjan Das versus State of Assam, reported in 2006 4 GLT 674. Also, accordingly, the case of the petitioner was considered and wide office order dated 24/10/2012. His case was held, by his case on being found to have lost its force as per the decision of this court in the case of Achyut Ranjan Das Supra, the claim of the petitioner for appointment on compassionate grounds came to be rejected. Subpara, being aggrieved, the petitioner has instituted the present writ petition. The petitioner had instituted a writ petition being WPC number
This one, Lordship, page 60, page
60.
59.
No, this one is there. Thereafter,
No, Lordship, it was ordered on 2014, it was disposed of on
but
2014.
this order was
But
not
prior
a
to
part
this-
of the.
Prior to this,
Huh.
their impugn order was
Okay,
passed.
okay, to ulta.
There was some correction also.
Correction. A case of the petitioner, যিটো High Court order আছে, সেইটো পিছত আহিব 2024-10-2012 to আগত আহিব. Did you challenge this order in 2014? You did not challenge this.
I did not challenge because it was filed in the year 2012.
12.
So by the time I did not receive this impugn order.
Also,
After
the petitioner, however, had approached this court by way of by way of instituting a writ petition being WPC number 3961/2012. However, without assailing the order dated 24/10/2012. The said writ petition was disposed of by a coordinate bench of this court by directing the respondents to consider the case of the petitioner in terms of the decision in Achyut Ranjan Das Supra Ekini. Also, the petitioner's case not being considered, the petitioner being aggrieved by non-consideration of his case after passing of the said order dated 21/11/2014 by a coordinate bench of this court, had instituted the present writ petition. I've heard the learned counsel for the parties and perused the materials available. The father of the petitioner had died in harness on 10/5/2005. The petitioner is found, case of the petitioner is found to have been placed before the jurisdictional district level committee in its meeting on various occasions. Also, however, the case of the petitioner was found to have not been considered on account of there being no vacancy for the purpose within the 5% quota mandated for appointment on compassionate ground. Also, this court in the case of Achyut Ranjan Das Supra had laid down the following principles with regard to consideration of an application for appointment, consideration of the case of an applicant for appointment on compassionate ground. So, in terms of principle number 10, as noticed here in above, an application submitted by a claimant for appointment on compassionate grounds, if remains not unconsidered for want of vacancy, such application after a period of 2 years shall be deemed to have lost its force. The application submitted by the petitioner in the matter way back on 19/1/2006, which was placed before the jurisdictional district level committees on various occasions, but was not considered for want of vacancy, has to be held to have lost its force in terms of principle number 10 of Achyut Ranjan, the decision of this court in Achyut Ranjan Das. Accordingly, the claim of the petitioner made in the present writ petition not mandate any acceptance. Having drawn the said conclusion, this court also would observe that the father of the petitioner had died in harness on 10/7/2005, and thereafter it is seen that more than 20 years have passed, and the petitioner and the claim of the petitioner in the meantime has been rendered a stale. So, it is a settled position of law that in the event of matter, so it is settled position of law, such stale claims cannot be directed to be so considered for appointment on compassionate grounds. Refer Devobroto Tiwari. So in view of the above conclusions reached by this court, the present writ petition is held to be devoid of any merit. Accordingly, the same stands dismissed. However, there would be no one.
Only one thing, Lordship. There was post for SC. The petitioner was a SC candidate, but he was
Supreme
not.
Court has said, fault is this side.
But the thing is that there's some.
Compassionate after 20 years, Mr. Sir.
There's some. Yes, Lordship. That's true, Lordship. Oblige, Lordship.
Yeah. Yeah.
Sir, I have inquired, Lordship.
Hmm.
He is receiving salary from the GAD department, Lordship.
GAD.
Lordship.
How?
Lordship, budget, GAD.
Mr. Pukand, you are paying him salaries. The salaries are paid by GAD.
My lord, I'll get my instructions from him. So he has said something, my lord, that we are paying. Let me get my instruction. He has not brought the written instruction. Let him bring written instructions. Then
I'll bring. I will also.
That will be.
But if you are paying, that means he is your employee, then he is in your part. No, forget it. What has happened has happened. We can't. You can't have it. If you have recognized him as your employee, you will have to.
It goes, Lordship, Secretariat and attached officers. It is under the attached office of the Secretariat, GAD department, Lordship. It goes as General Administrative Department within bracket.
How does it go?
General Administrative Department within bracket, Secretariat and attached offices. So from GAD, he has been paying it. Salary has been paid, Lordship.
I'll get that instruction from the account department.
Mr. N. Upadhyay, Land Standing Counsel, Irrigation Department, and Mr. A. Pukand, Learned Standing Counsel, GAD, shall place on record written instructions with regard to the service status of the petitioner, more particularly the manner in which the petitioner is now being paid his salaries. Mr. Upadhyay, Mr. Pukand had submitted that the petitioner is not an employee within the cadre strength of the Secretariat employees. What is that employee service called? In the cadre strength of the, what is the of the Secretariat Administration Department, which is disputed by Mr. N. Upadhyay. Accordingly, to facilitate the learned counsel for the respondents to complete their instruction, the matter stands adjourned today. Also, registry to list this matter again on 25/5/2026 for further hearing.
Lordship, all right.
Time being.
Yes, what is it?
This paper here, the petitioner date of birth was wrongly incorporated in the service process. One here is recorded as 28/12/1956 and another as 28/7/1966.
My lord, here two dates were recorded, my lord. First one was, my lord, due to the mistake of the one of the office bearer, my lord, as it is reflected from the inquiry report.
You are not a matriculate.
No,
Have
my
you
lord, no.
cleared your matric?
No, my lord.
Where is your service book? Where
Yes.
is your service book?
My lord, that is, I have annexed here, full certificate, page 21.
When did you join?
I joined in service, my lord. I have annexed here of the appointment letter also, my lord.
Okay, tell me the date.
Yes, my lord, 19 July at 85.
Regular,
Yes, regularized 2005.
MR,
MR, my lord. Annex 2, page 17.
regularized on with effect from 22.
My lord, effect from, with effect from 22/7/2005.
What is your date of birth as per?
Yes, according to me, my lord, it is, my lord, as it is evident from the voter ID, my lord, PAN card, my lord, Aadhaar card, I card, etc., my lord, 28/7/66. 28/7/66. School certificate also. But my lord, it is evident from the, my lord, GPF account, it is date Annexa 6, 28/12/1956. 28/12/1956. And enquiry report, my lord, what has been already completed, my lord. Both the dates, discuss about both the dates, my lord. Enquiry report that is, my lord, conducted on, my lord, 20/10/2020, my lord. It is in the affidavit opposition filed by the respondent number 3, page, my lord, 41. What's they have mentioned both the date of birth, because initially it was 31/12/56, and subsequently, as it is evident at the time of regulation of service, my lord, petitioner submitted his school certificate.
Okay, where is your order which was forwarded to the authorities? Particulars forwarding your name. Have they filed any affidavit here?
Yes, they have filed, kindly peruse your lordship, page 41, my lord. In the affidavit opposition filed by the respondent number 3, enquiry report. As
Where was the school certificate you produced?
yes, my lord. School certificate I have annexed here in my repetition also, my lord.
I could see Milan High School.
Yes, my lord. And they have enclosed one certificate, my lord.
Hmm.
56, my lord.
Uh,
And they claim that, my lord, my time impression is also there, my lord.
uh,
That it is, my lord. Yes,
Then have you denied this?
yes, my lord. They
Where?
have kindly peruse your lordship, enquiry report, the last bottom, my lord.
Where is the inquiry report?
Enquiry report, page 42, my lord, relevant portion.
Hmm.
41 starts from examination of the record. Service book Bolenboro has been examined. The date of birth superannuation has been recorded 31/12/16, and the service book has duly signed by the executive engineer PWD Borpeta Road Division so and so. Letter issued by the undersecretary so and so. School certificate 31/12/1956. It was earlier recorded, and subsequently regarding the new page 42, my lord, relevant portion. Middleman, I have star mark there. 1/12/2022, the undersigned held meeting with Pratul Chandra Das, Deputy EAO, Diwan Chandra so and so, wherein they furnished the following facts with the record after through scrutiny. Copy of the service book, letter issued by the Undersecretary so and so, dated 30 September 2005. School certificate Bolenboro, where his date of birth has been recorded at 31/12/56. There have been sterling facts produced before the undersigned with the following information. School certificate of Bolenboro, where his date of birth has been recorded 31/12/1966, issued by the headmaster Kayakoshi so and so. PAN card of Bolenboro, where his date of birth has been recorded 31/12/66, issued by Income Tax Department. Identity card of Bolenboro, where his date of birth has been recorded 31/12/66, issued by the Assistant Executive Engineer, Patsala revision so and so. And all these records appear to be clearly manipulated by the concerned dealing assistant Mohananda Sharma in condiment with the Bolenboro MR labor. The statement furnished by Bolenborough erstwhile MR Lebar has been truly examined along with all the relevant record in his regard. As stated in proceeding paragraph, Sri Bolenborough appears to be equally guilty, although he was implicated Sri Mohananda Sharma in this entire episode leading to huge financial irregularities. It may be specifically mentioned that Bolenborough was due to retire on 31/12/16 as per the record verified. I have carefully examined the considered facts, relevant records, and circumstances of the matter. In my considered opinion, Sri Mohananda Sharma is prima facie held totally responsible for allowing Bolenborough to continue up to July 2020 and hereby incurring an unbearable financial loss to the government exchequer to the tune of rupees 12,46,113 rupees. Authorities may desire to initiate appropriate disciplinary action against Mohananda Sharma and Bolenborough deem fit as well to the recovery of rupees so and so. The statement of Bolenborough along with the other witnesses enclosed herewith. Thereafter, what is happened? They have also one affidavit opposition filed by the respondent number 3 again, my lord, where they censure punishment was given to the said page, my lord, 56, annexure 1. Mohananda Sharma, my lord. Thus censure, my lord, under section 7(1) of the Assam Services Discipline and Appeal Rule. Censure, my lord.
Who has given censure?
Executive engineer.
Our Mahananda Boro.
Yes, my lord.
Mohananda Sharma.
Yes, my lord. Annexure 1, page 56. As per the findings and report submitted by the inquiry officer against DP case number so Mohananda Sharma.
56.
Yes, my lord, 56. It was affidavit opposition filed by the respondent number 3, my lord. 12/6/25.
But they have said that it is proved. That he had manipulated, that is proved.
No, but what is happened, my lord, so far my papers are concerned, my lord. I have annexed second repetition. I have also challenged the, my lord, said inquiry report also, where I have all annexed all papers, my lord, because all the papers, voter list, my lord, that is.
Now this,
PAN card.
where is the original date of birth, full certificate that you relied when you joined?
Yes, I have that.
Original one.
Original one.
1970, 85.
No, my lord.
1985.
The certificate, my lord, I have that one. देखिए सर्टिफिकेट नहीं है।
What is the date of birth you now claim?
Well, 28/7/66. Process.
I don't want this. I want the original certificate you submitted in 85.
No, my lord, so far this certificate is
This is 2005.
2005, my lord, at the time of regulation he has placed it. But that is not me, my lord.
Then how come your date of birth was recorded as 1956?
Because, my lord, earlier occasion inquiry, it is, my lord, and this office, Mohananda Sharma was directed to bring this, my lord, copy of this certificate, my lord. That is not available with me, my lord.
Who signed it?
But put thumb impression was put there, my lord. But I can sign it,
You have
my lord.
not disclosed that in your writ petition. Yes, Mr.
Lordship has started the prayer. What is the
Which
prayer?
one? Which one? Which one?
Writ petition, Lord.
Now, which writ petition? The two.
1678/2024.
Okay.
Lordship, may kindly see the first prayer.
Hmm.
Here he has prayed for setting aside and quash the impugned letter dated 30/9/2020. That is the first prayer.
Hmm.
That is Annexure 5. Lordship, may kindly see Annexure 5 at page 23. Lordship, by this letter, an inquiry was directed. Subsequent to inquiry has already been done, wherein he has participated. So far as the first prayer is concerned, this
Got it.
in first verse. Lordship, may kindly see the second prayer. A writ in the nature of writ of mandamus shall not be issued direct the respondents to release him arrear salary as well as current salary with effect from the month of August 2020 till his reinstatement in service as a regular MR labor till reaching his actual date of retirement, that is 27/7/2026, by accepting his correct date of birth as 28/7/1996 upon correction of his service book, etc. So what he is praying? Basically, a prayer for correction of date of birth in the service book. So where is the denial? And when this representation was made for correction of service book?
As per 1956, he will retire in 2016.
16. So he overstayed for some period also. So that is a different issue. So far as this writ petition is concerned, it is only a prayer for correction of the writ petition.
Other one is also the same.
Not
Other one is also the same.
Same. That is the only prayer.
Rectification would be under 8C
Yes.
before 3 years from the date of your superannuation.
But already he has submitted 66. They have admitted it.
No, but from where did
They-
56 come?
And
56 I
my lord, so
understand. From where did
that
56 come?
that was directed to bring their copy of this, an original copy of this school certificate. They
No,
cannot
original
be able
copy
to-
we cannot bring.
Cannot
That
you-
was submitted by him only.
What you gave
No,
a
however,
copy.
from it
Are-
was my lord,
During
deposited-
the inquiry, it was submitted by him. The photostat copy.
direction was there to submit the copy of
What
the
has been
earlier-
directed to me is to bring the
earlier
service
order,
book.
my
Lord.
lord.
You have the service book with you?
Yes, this
Just
is
show me. Where is this 56 birth certificate? Oh, this is the birth certificate.
that is the copy, Lordship. And that was submitted by him during the inquiry itself.
When was the inquiry held?
Lordship, it was pursuant to Annexure 5. Lordship, it was by
Wait,
letter dated 30/9/2020.
Hmm.
So that is the case, Lordship. If Lordship requires, Lordship, I can place few judgments as regard correction of date of birth, Lordship.
Mr. Das, where from are you saying that this 1956 date of birth school certificate was brought by the respondents, not by you?
Because
Who are you saying that? From where? What is the material?
not that, but that was not supplied by me, my lord. This certificate was supplied by me.
Then in 2014, the service book was prepared? In
This
your presence?
certificate was submitted by me, my lord, this at the time of regulation of service. Earlier, Mohananda Sharma, where from, my lord, put this
That
certificate?
is what Mohananda Sharma brought it. Where is the material?
That I have not the data.
Have you averred that? Have you made statements to that effect? That it is Mohananda Sharma and Mr. Nayak, I mean the department who had brought it? Any statement, anyone?
Yes, yes. No. I have stated in a second writ petition, my lord, page 9, paragraph 8. That there being agreed with this would be lettered at the 39/2020, your petition appeared before the inquiry committee on, but as no result come out, he had-
Where? Para 8.
para 8, my lord. It's 638425. The Honorable Court is still pending. During the pendency of the case, one affidavit of opposition was filed by the respondent chief engineer. So where
Okay,
the,
where is that? If this was done by, manipulation was done by the departmental authorities.
just I have mentioned where from your petitioner could come to know.
Oh,
that-
that is.
Yeah, but there are some wrong information and
Wrong
dates
information in the inquiry report.
Yes,
But what is that
incorporated-
wrong information?
in the inquiry report which are not at all correct based on some wrong view taken by the department. Prior to it, personally, my lord, I have not mentioned it. Really.
Okay. Heard Mr. H. Das, learned counsel, for the petitioner. Also heard Mr. P. Nack, learned. Standing, additionally, Advocate General Assam, appearing for the state respondents, and Mr. P. Boro, R. Boro, learned standing counsel, AG, bracket Assam. Hearing-
My lord, I have mentioned that is
Next paragraph.
paragraph 10.
Hearing concluded, but in your first writ petition, there is no such mention.
That was I have heard from, I collect that information.
Ah.
Inquiry report, I have come to know. That. Paragraph 10, I have
Hearing
mentioned.
concluded, registry to list state criteria. 22-5 for delivery of orders.
Paragraph 10, my lord. In the second report. That it is the department collected by the department as where from they are no such valid basis.
Something not otherwise coming up. But something coming up,
And if two dates are recorded, my lord,
two dates,
Yes,
you.
already it's numbers of judgment, my lord.
Oh, your Mohan.
Pandey, Jogeshwar Pandey judgment.
Mohananda Sharma and you together tried something, but did not work.
So for my lord, voter IDs, PAN card, everything are 63.
Another thing, Mr. Counsel,
That's it.
Mr. Das, there is a requirement that if you are relying on a school certificate, that has to be certified by the jurisdictional deputy commission. That is also not there.
That was possibly not prevalent at
That
the relevant
is
point of
not
time.
there. Because that certificate, there is a OM of the government.
But they have
God.
accepted as it is evident.
There is an OM.
Yes, Lord.
There is an OM that if such certificates are to be relied upon, that has to be verified or counter signature by the jurisdictional district commissioner.
If the person concerned is
But
under.
would they said certificate,
Under metric.
but would they said signature and seal, my lord, they have accepted as it is evident for the inquiry.
So then there are, yours also is that we will accept not both we will not accept. We will say that this is a man without age, without a date of birth.
66, it is, they have mentioned,
Your photograph doesn't show that you are 60s.
but
The
here,
photograph is much more.
already,
detailed.
I have also have that, my lord, voter ID, PAN card, Aadhaar card, all
These
everything.
those
are
are
all
Mr.
subsequent documents, Lord.
No, today I can go and create a thing for that myself. I can just file an affidavit saying that my age is 21 years old.
But other so far documents are concerned, I have
These are not documents by which you can,
original. Anyway, my lord,
a very dangerous proposition if we have to
Yes.
rely on that.
Yes. I mean,
Yes.
we have all, so far as this issue is concerned, we have suffered a lot, Lordship.
I have also
He is not the only.
deprived,
we have
deprived, my
suffered,
lord.
and we have lost many cases, Lordship, because it was not, I mean, properly assisted to the Honorable Court. But this is a case, Lordship, where his only prayer is for correction of date of birth, nothing beyond that, Lordship.
You can't correct a date of birth before 3 years.
From
Obliged, sir.
August onwards, I have stopped to receive any salary and
No,
pension.
we'll give you pension.
Yes, my lord.
We'll give you full pension. I give him a provisional pension. It is provided that as the petitioner had already served the department, subject to further orders passed by this court.
Lordship will decide the issue that he has already, I mean, he is not claiming any benefit beyond 2016. Lordship, I'm ready to be.
Oh, you give him
Pension.
provisional pension. He
On the
took
basis of which calculation, Lordship, 2020 or 2016?
1956.
56.
Yes.
I'll pass the order.
Yes, my lord. Always.
Madam. Heard Mr. Arsham, Learning Council for the petitioner. Also heard Mr. E. Kaushik, Learning Council, Secondary Education Department. Although the names of the Learning Council appearing for the respondent number 8 is reflected in the cost, but none has appeared for respondent number 8. Although none has appeared for respondent number 8. Respondent number. 5, 6, 7, and also. Hearing concluded. Registry to list this matter again on Kundinapari. 26/5/20 for delivery.
Lordship. My lord, morning I have prayed, my lord. A distinguishing factor is that my prayer is that Pandamas to declare that we are regularized. My lord, why I am saying that, my lord, page 33, the UDV that has conducted a, my lord, selection test after the approval that, my lord, regularize us, my lord. Now, after, my lord, going to, my lord, RTI reply, we cannot finance also given the concurrence, my lord. Page 56 of my lord, additional regional affidavit. So at this
Mr.
stage,
M.J. Borwa, Learning Council for the petition. The matter was heard at length on 8/4/2026 and was placed today for further hearing. Mr. Borwa submits that he be granted a week's time to file additional affidavit to bring on record certain documents which would have a bearing on the adjudication of the issue arising in the present petition. Accordingly, registry to list this matter again on 28/5/2026.
obliged.
Any urgent matters?
So far, this part is, matter is concerned, it may be taken up on Tuesday next, my lord.
Which one? Item number 18.
18, my lord. But my lord, petitioner's health is not, my lord, good, my lord. So, disposal of this
Okay,
matter.
he'll give you a date. Date diri ba hai? Any urgent matters?
Item 20, my lord, is, my lord, relating to man is already retired on 31st March, my lord.
Ah,
And my lord, there is order of this honorable court to, from department, my lord.
that promotion case.
Fixation, my lord, and
Cultural affairs.
fixation of, no, my lord, fixation, that is already gone, my lord. There is a college professor, my lord, as,
Okay, consider.
fixation of pay, my lord, and it is not,
Consider.
my lord, date, or today or
Some other day she'll give you a date.
my lord, and date may fix, my lord.
She'll give you a date.
My lord,
Yes, Mr. Rek.
my lord, 21st, 19 May, my lord, or,
So that subject to vacancy,
my lord, already, my lord, this is.
subject to vacancy.
College asks man to.
That is not mine, that is her thing. I can't do it.
Same with item, regard to item number 19, my lord. If a date can be fixed, I'll.
Be fixed. Anyway,
My lord, item
congratulations.
number 27, my lord.
And
Contempt.
that we have allowed your writ petition.
Hello.
Ankur, we have remand not allowed, we have held your misrepresentation to be correct and we have asked them to act according.
My lord, item number 27. This is a contempt case. Your lordship has directed for payment of pension and
Ah.
arrear salary.
Item number?
27.
Hmm.
And that to put to challenge before the division, and that was also dismissed.
Hmm.
Even after that, my lord, I have not received any benefit for last 3 years. No pension, no arrear salary. It is a retired
Item number?
27. Directed to appear in part.
Yes, yes, Mr. Who is appearing? Yeah, 27 day.
Will lodgment direct for personal appearance. my lord. He is a retired teacher without any benefit for last 3 years. my lord.
Where is the order violated?
My lord, page, my lord, 9 to 17. Last 2-3 orders, my lord.
Division bench dismissed.
Yes, my lord.
Where is the order?
In the order sheet, it was reflected, my lord, previous 2-3 orders.
Asa nahi given. Then give us it.
Those order is there with me. This case was fixed for compliance report, my lord.
When was the division bench order?
7/11/2025.
Mr. P. Kaushik, learned counsel appearing for the respondent has submitted that the department is taking steps for assailing the order passed by the division bench before the Honorable Supreme Court. Accordingly, he prays that the matter be taken up on July 2026, on which date either the order complying with the directions passed by this court and or the filing of proceedings, the materials envisaging, documents envisaging filing of proceedings before the Honorable Supreme Court shall be placed on record. My lord, copy of the instructions punished by Mr. P. Kaushik is kept on record and marked as X mark. I will give you some more time.
Yes, ma'am.
28 query.
My lord, item 36, my lord, interim order may be continued there, my lord. Transfer matter, my lord.
Interim order.
Just
36.
36, my lord.
35 and 36 are together.
Together, my lord. 36.
Both interim orders are there.
No, madam. In 36, interim order is there. That may be continued.
Transfer matter. Yes. Now, 35. Who is there for 35?
In 35, my lord.
You are there in both.
I am in 35, the private respondent, my lord.
Hmm.
There, my lord, the petitioner claims seniority over me, my lord.
Transfer matter.
Second one is the transfer matter.
Okay. Then why is it together?
My lord, they have wrongly, my lord, I have not made the party, the petitioner, in the first case, in the second petition as a respondent, my lord. On last occasion, they have wrongly mentioned this matter. And this was, my lord, tagged together. They are not the party, in fact. Maybe segregated, my lord.
Item number 36. Huh? 36. In the prayer of the Learned Council for the parties, registry to list this matter again on 22/5/2026, along with WPC number 1469/2020. Interim order passed earlier to continue till the next date of listing. Huh? WPC 1469/2024. Also, has prayed for registry to list this matter again on the same date of deliver, along with WPC number 5814.
Obliged, my lord. Reply.
Motion matter item 16. This is for timing.
We called up, you were not here, you were busy. Thereafter, this court got busy. Can't help it. Happens. Okay, we'll hear it. Have you given the documents to Mr. U. Sharma
Yes, sir. I have given.
for verification?
Yes.
Yes, counsel, what is that?
Item 41, Lordship.
Hmm.
It's a hearing matter, Lordship.
Hmm.
Lordship, the petitioner, we are challenging the dismissal, Lordship. Since 2023, Lordship, he has did not get any benefits, Lordship, due to his dismissal, Lordship. So, Lordship, if it may kindly come up for
Come, please. Deliver hai, hearing matter kita. Come.
Obliged, Lordship.
Like this. Both were regularized on the same day. So the authorities have taken into consideration their initial date of appointment for the purpose of sin.
Oh, both were honorary.
Both were honorary. They were regularized in the same day.
How can you regularize? How did you
I
appoint
guess
them
it
as
is-
honorary?
That's
If that is so, I made a mistake.
no, my lord.
In following Dambuda, Kolita, that cases and dismissing of poor petitioners' cases. If this is the stand of your respondents, we will say that the permissible in spite of orders by this court.
Otherwise, there are.
Was provincialized long back.
And that's a proposition laid down long back, my lord, that
Then how did you do this? And your director is very boldly writing a illegal action to be a legal one. Also, Lekha. Heard the Learned Council for the parties. Mr. P. Kaushik has placed on record the instructions received by him in pursuance to the order dated 22/4/2026 passed by this court. The same would be considered on the next date of listing. Also, registry to list this matter again on Undina Pari.
motion.
8-5. 11 pass per year. 11-5, 2025 for father. Here. You find the answer for.
I'll,
Okay. Anything dates are there, please?
Item number 25, my lord.
Hmm.
My lord, in this case, my lord, we have filed our RTI application, my lord. Sought for certain certain information, my lord. And we have filed our RTI on, my lord. 25/4/2025, my lord. And
What is the urgency?
my lord, I'm working in the
You don't know your facts very nicely. You read it, we'll take it up after some time.
yes, please.
after some time, Lordship, say.
Sometimes means after 2 weeks.
Yes, Lord.
Because now they ask for time, that is, I also said time.
Lordship.
Mr. Counsel, you read your brief, come back when?
My lord, they can't today, my lord, because my second appeal is pending, my lord.
Second appeal
It's pending, my lord.
Filed on?
My prayer is that, my lord.
Filed on? Second appeal filed on?
On my lord, 6,
You don't know that date also.
not one, no, my lord.
Yes, Mr. Deka, what has happened?
There is a second appeal which was filed in August 2025, which has not been taken up because we are taking it serially. If Lordship allows us, it passes an order, we'll take it up.
Why should
Lordship,
I, why should I ask a statutory body
out of
to
turn.
take up a case out of turn? If there is an urgency, he will make
Yes,
an
Lordship.
application, you consider.
They have not made it.
The petitioner, on the prayer of the learned counsel for the parties, registry to list this matter again on 19/5/2025 for further hearing. I'll pass the orders.
Yes, Lord. Highly obliged.
Today, my people are very tied up. That's why I don't want to saddle them with anything more. That's why.
Simple, my lord, that direction will be given.
Yeah, file, yeah. Okay, we'll take it up.
Lordship, we take about 19 only.
No, today. How many commissioners you have now?
Lordship, we have two at present, Lordship.
Only, there is no chief.
No chief commissioner. He's acting chief. One of the commissioners are acting as a
Acting.
chief.
Is there any time frame prescribed under?
No,
the-
Lordship. For the second appeal, there is no time frame.
Yes, what is your name, Mr. Counsel?
V passport, Vinod passport.
Vinod Passport. But Mr. B. Passport, we are dismissing your application. Vinod Passport, we can't direct a statutory forum to, you go and file an application there, they will consider.
If
There are many people who are there.
and
Heard Mr. B. Passport, learned counsel for the petition. The present application has been, petition has been, also heard Mr. D.K. Deka, learned standing counsel, Assam Information Commission, and Miss D. Bond appearing for the respondents number 2 and 3. The present petition has been instituted, praying for a direction upon the Assam Information Commission to expeditiously consider
yes, madam.
the
Second appeal, my lord.
No, you have also challenged Annexure 11,
Yes, ma'am.
7-7.
Yes.
Yes, what is the ground for that? Yes, what is your ground for that challenge?
My-
Because your application is not found in format.
We have filed the application along with the apostolic application, along with the necessary fees, my lord.
Necessary fees will not do. You'll have to
That
be,
is, we
follow the
submitted
format.
Rupees 10 IPO, my lord,
Hmm.
but there is some misplace done by the responding department, my lord.
Respondent, where is your allegation to that? That they have done the misplacement.
There is some.
Where is it?
mistake of my
Tell
lord.
me. I don't know. I only can read. My eyes are closed, ears are
Mistake or
closed.
anything. So
I can only see.
again,
Where is it? Tell me that they had misplaced that. Where is your application for first appeal?
so annexure 5, my lord.
Annexure?
5, my lord, page number
53, Lord.
20. 20, first appeal.
20.
20, 53.
Others can go. We are not taking up any other matter, only this one.
53, my lord.
Hmm?
Case 53. my lord.
53. Hmm. Hmm. Okay. Where is the original of this? Original of this. This is the original.
Yes, my lord, this is-
You have said that the rupee 10 has been misplaced.
We have
Right.
submitted.
You
by
submitted
filing
it
the
was
art-
misplaced.
right.
Come to page 56,
Yes, my lord.
clause 12.
Okay.
Where is the particulars of that? So what are these allegations you are making? That too against a judicial institution.
We have submitted, but
Now we are going to impose cost upon you. Because of the wrong information, misrepresentation.
not my lord. While submitting the right.
Arre, where is that details? It is to be filled up here. For filing second appeal, you don't require fees.
No, even the Act doesn't prescribe even the fee for the first appeal. However, the High Court has notified by the rule.
By
That will be applicable. Lordship.
that discretion is.
Yes,
there.
Lordship. As an appropriate authority.
Yes. How can you say that the first appeal, that challenge, because that they have, you have not even mentioned what is the IPO number. You have not even mentioned that IPO number even in the writ petition. Hmm. Okay, now come to the
My lord,
prayer number 2.
My lord,
Huh? What?
kindly come to my lord, page number 9, sorry, page number 8, point number 9, my.
Huh.
That the petition beg to state.
That is it. Where is the number? Where is the number of your IPO? That you saying that you submitted an IPO will not do. You will have to give us that this is the IPO I submitted. It is misplaced. Then we will ask. We'll ask the postal department that this IPO was issued in whose name. Then we will know, yes, it was issued in your name. So that prayer is gone. Prayer number 2, come. Come to prayer number 2. Page 12. Prayer number 2. Page 12. Writ of mandamus shall not be issued by giving a specific direction to respondent number 1 to compel the other respondents to provide information. Now, how are they to compel? By putting them behind bars, by verbal abuse, by physical assault? How? Three is okay. But what about 2? So this is a frivolous petition. Is there any provision for making mention and all those things?
Lordship, we do consider if they file an application before
Application.
they file an application. We do consider on its own merit.
Yes.
Simple prayer is that, my lord.
Huh?
A simple prayer is that, my lord, that second appeal is pending, my lord. That may be.
That will be pending. That will go in terms of the procedure they have. I don't like anybody telling me, hear that matter. A request can be made. That's a different thing. A request can be made to this court and we will consider. But even we don't ask anybody. Supreme Court does not say. It says, okay, consider. How can we direct? We can't. Withdraw this, approach them with an application. I'll ask them to consider that. Mr. B. Basfo, learned counsel for the petition, after attempting to argue the matter at some length, submits that he be permitted to withdraw the present petition with liberty to approach the Assam Information Commission for praying for an out-of-turn hearing in the second appeal filed by him. Prayer accepted. Registry. A prayer accepted. The present petition stands dismissed on withdrawal with liberty as prayed for. Mr. D. Mohanto, Mr. D. Deka, learned standing counsel, Assam Information Commission, and Ms. D. Mohanto, learned counsel appearing for the respondent number 2 and 3 are present.
Lies, your lordship.